May it please, your lordship. My lord, in regard to item 9, my lord, I
Nine.
need a little bit of accommodation for a week only.
Labor matter,
My lord,
I think Benchpur. Or perhaps Benchpur. Only. Labor in industrial cases.
yes, yes,
Not bench 5, wrongly listed.
maybe.
Mr. S. Doctor, and Senior Counsel for the petition, has sought a short accommodation for a week. Also, the request made by Mr. Doctor is with the consent of the
Yes, I've taken their consent.
Senate Council for a respondent. First up. Release the case accordingly. After a week. Stop. Subject matter of the petition is labor and industrial cases.
Yes,
First up. Office to verify the same and list the case accordingly.
obliged.
My lord, what will be the date, next date, this case?
No, this is not bench 4 matter, bench 5 matter. So I have asked the registry to verify and list it accordingly after a week.
May it please your lordship. I'd like to draw your attention to the item number 8, my lord.
8.
8, my lord. My lord, I have taken the consent from the other side. Can it be adjourned for a week, my lord?
Who are you for the petitions? Mr. S.K. Deka, Senate Council for the petitioner, and is present. Mr. K. Bharsaiji, Senate Council for the respondent number 5
to 12.
212,
Yes.
has sought listing of the case after a week. So stop as the there is the consent of the Senate Council for the petitioner and other sides. The praise the Lord, leave the case after a week.
Lordship, I would like to mention for an admission of a WPC matter. It was last listed on 1/5/24. We got time for 1 week. We got time for 1 week for a posting of next date. It's pending, not listed.
Subject matter,
Subject WPC matter.
WBC,
WPC.
that I know.
Arbitration matter. It was an arbitration.
Which year?
2024.
Okay, Devo.
May please, your lordship was taking up to tag matter regarding personal on 14, my lord, fixing tomorrow. Now, 1 matter has been listed, 1 is not. My lord. May I pray that matter will be listed?
1 meter is?
Is listed tomorrow, my lord. 1 is not.
Hmm?
It was 2 tag matter, my lord. For regarding personality, my lord. Your lordship
Yes.
was hearing on 14th,
Yes.
fixing tomorrow, my lord. 1 matter has been listed tomorrow for tomorrow, 1 is not, my lord.
Only.
Yes,
Oh,
lovely.
If I may please the lordship, I beg for listing a matter for withdrawal on 17. May I please lordship, I beg to mention item number 11, lordship.
11.
Lordship
Don't
for,
tell you mention mostly. Yes. You are for whom?
for A. Kalida, Industries and Commerce Department.
You want adjournment?
Yes, lordship.
You are for the petition?
Lordship.
Okay, Mr. M. Das Learned, Counsel for the petitioner, and Mr.
In Kalita.
N. Kolita,
Yes, lord.
Learned, Counsel representing Mr. A. Kolita, Standing Counsel Industries and Commerce Department. For the respondent. Are present. Mr. Kolita has sought listing of the case after what?
Lordship, after a week,
After a week.
Let it be 2 weeks, lordship.
Huh?
Let it be 2 weeks, lordship. Let it be 2 weeks.
2 weeks.
Yes.
Okay, 2 weeks. As the prayer is not posed by the Learned counsel for the petitioner, released the case after a week.
Obliged.
For Union of India, Lordship.
Mr. K. Gogoi, Learned Central Government Council. He is also present. এখন তাতে থৈ দিবচোন কি
May I please, Lordship?
এটা বাৰে বাৰে সোমাই আছে Yes,
Would
Good.
you liberty to refiling, Lordship? Kindly allowed to do filing.
Mr.
H. Islam. On
H.
be-
Islam.
on behalf of
Your
B.
name is
Sinha.
not there.
On behalf of B. Sinha.
Learned counsel appearing on behalf of Mr. B. Sinha, Learned counsel for the petition has submitted that the petitioners want to withdraw the petition with the liberty. With liberty. Full stop. Labor society. Revenue for one. K. Gogoi or Angusami. Learned additional senior government advocate or junior government advocate Assam for the response number 2 and 3 are present. Due to above submission made by Mr. Swenson, Learned counsel for the petitioner, and the petition is dismissed on withdrawal with the liberty. Come on, spirit.
Obliged.
So item number 13.
Anyway,
Item 13.
we issue,
May I please?
with observation, we'll issue notice.
Lordship.
Heard Mr. S.I. Akban, Learned counsel for the petitioner. A for the side,
Single.
Learned standing counsel. Revenue and Disaster Management Department for response number 1. Finance, MS RM Borua. Learned counsel representing Mr. B. Good and spending counsel. Finance Department for the response number 2. Angusami, Learned Junior Government Book Assam for the response number 3 to 5. Full stop. In this petition, the petitioner has posited that her husband,
Yes, Lordship.
here is it, late Babul Das, expired
26/06/23.
due to drowning on 26/6/2023. Full stop. Contending that the it due to drowning took place at a public place. The petition has preferred the instant petition seeking a direction to the respondent authorities to disburse a sum of rupees 2 lakh as ex gratia in terms of a notification
15/11/2014.
dated 15/11/2014 of the Revenue and Disaster Management Department from a government of Assam. A perusal of the notification dated 15/11/2014 goes to indicate that the state government has framed a policy to extend relief in the form of ex gratia in case of in cases of killing in certain situations, killing within bracket, quote unquote. There are though both quote unquote die and quote unquote kill have to do with the ending of life, comma, there is a slight distinction. There is however a slight distinction. Full stop. Literally, comma, quote unquote kill, die, quote unquote die, means to stop being alive, semicolon, to cease to life. In their plain meanings, literally no. Whereas quote unquote kill means to cause someone to die, semicolon, to make somebody die, full stop. The notification dated 15/11/2014 has stressed on quote unquote kill, comma, not quote unquote die. Full stop. That's the next paragraph. That's the issue which should put for consideration is whether an event of death due to drowning without any act of others would fall within the ambit and scope of the notification dated 15/11/2014. Issue notice returnable in 4 weeks as so and so so and so. Extra copies, 3 working days.
Much deeply.
Item 14.
Yes. Yes, it appears to be bit premature. You will have all the opportunities. You have a claim on the basis of patta.
Yes, to after section 4 notice, yes, to reduce everything before the state of.
In fact, my lord, they
And
had
even
put it-
lordship, without issuing the,
Premises to sound.
without issuing the section 5 notice, we lordship cannot proceed for eviction laws. And against that, section 9 provision is there lordship.
Yes, what do you say about
State
section
provision is
5?
there lordship.
Hey, very good.
If this is test lordship give issue.
Very two. Mostly what is the sound? Have you gone through section 5?
my lord, I have done.
আছে নাকি এটা? আছে? এটা মেক্সকো বুলি আছে, মেক্সকো, MESCO. MESCO. A notice can be heard through his representative also.
There is a
Yes,
provision,
ma'am.
Lordship.
My
there is
lord,
a provision.
all the provisions were there, my lord, that state officer, my lord, was not in a mood, my lord. Kindly see, my lord, what happened, I am stating, my lord, what the actual facts were there, my lord. Even, my lord, Gabura was there, my lord, on legal
We'll
advocate,
create the mood.
my lord.
We'll create the mood. What you have, Patta?
My lord. Yes, my lord.
How?
My lord, page, my lord. Page 26, my lord, is the office.
You are from the same family or different
My
family?
lord, they are, my lord, joint partner, my lord, same family. My lord. And that land was
Where are the notices?
on notices page, my lord. Page
Page
33 onwards.
33 onwards.
And
Schedule is there, Lordship.
Kurmara. Kurmara. Where is the Jamabandi or Jamabandi?
My lord, page 26, my lord.
Village.
My lord, village, Bortespur, my lord.
Hmm?
Village, Bortespur, my lord.
Village? And the percent to so. Where it is reflected, page 27. Joripua. Rampur. Or your type copy,
My lord, I have
page
the
26.
type, is the, my lord, the circle officer order, my lord, department
Right.
order, my
Where
lord.
is the name of the village reflected?
Lordship, it is there, Lordship.
Huh?
In the first Joripua Gaon, next line, Lordship. It is there, Lordship. Ek Nong Lai / Tezpur
Bortespur.
Ek Nong, Lordship.
Rampur something, Eknongla.
Rampur, my lord, is the, my lord.
What?
And Tezpur.
Rampur is Moja, my lord. Under Rampur, Moja. And village name is Bortespur, my lord.
Hmm?
Village name is Bortespur, under Moja, Rampur, Revenue Circle, Palajbari.
Here it is reflected Tezpur Ek Nong, Lordship.
Hmm?
Tezpur Ek Nong, Lordship. Second line.
And in the Mojada
Main
or circle officer, let us see. Circle officer or something. Who is he? Village headman. Bortespur Gaon. Village Bortespur.
My lord. Bortespur.
here it is written Tezpur, Lordship. In Jamabandi, Lordship.
And in the notices, Kukurmara.
Lordship. Kukurmara and Sidul is also there, Lordship. 42.
Schedule I have seen.
Lordship.
But where is Bortespur?
It is not there, Lordship, in the notice.
At Kukurmara. It is there, my lord, railway, probably, my lord, they are railway division, my lord. Under that railway, my lord, states, my lord.
So, no,
That is why, my lord, they are-
railway land does not have any village or what?
my lord.
Railway land does not have any village.
Yes, blessed, there's a blessed.
Kukurmara,
Kukurmara kilometer 142 of
Moja is there.
Lordship.
Rampur. Rampur is Moja. Rampur is Moja.
my lord.
Do you have the original legible copy of Jamabandi? No. Heard Mr. S. Hawk, Learned Counsel, for the petitioners.
And Lordship, revenue receipt also, like, Blaze is Tezpur, Lordship. Revenue receipt, my lord, kindly page 25, Lordship. Page 25. Vernacular
Tezpur bought.
Gaon naam Tezpur. Tezpur, bought Tezpur.
Lordship. And revenue receipt only reflected Tezpur Lordship.
Then what does Gabura say? Bought Tezpur.
Lordship.
So we keep it Tezpur stroke bought Tezpur.
My lord. My lord.
What to do? And Mr. K. Gugoi, Learned Central Government Council, for all the respondents. Full stop. The petitioners come up 5 in number, 6 in number. Comma, have joined together to institute the present writ petition under present petition, seeking to invoke the extraordinary and discretionary jurisdiction of this court under Article 226 of the Constitution of India, pursuant to to assail eviction notices, comma, all dated 15/2/2024, comma, served upon them by the respondent number 4, comma, that is, comma, the state officer, NF Railway, Rongia. Para. The case projected by the petitioners is that they are members of one family and their forefathers, their predecessors in interest, were enjoying peaceful possession of a plot of land measuring 3 bighas, 2 kathas, 2 lessas, covered by DAG number 1627, Roman and Patta number 49, situated at Revenue Village, Bort Tezpur, Polakbari Revenue Circle, Moja Tezpur, Rampur, Polakbari Revenue Circle, Kamrup Metro or Kamrup Rural?
Kamrup rural man.
District Kamrup Assam. Post. The predecessors of the petitioners and the petitioners have been paying land revenue in respect of the subject plot since long, and jurisdictional mojarat has issued land revenue receipts acknowledging receipt of land revenue from the petitioners in interest of petitioners. Full stop. To substantiate such contention, the petitioners have annexed few of the land revenue receipts with the writ petition. Full stop. It is a further case of the petitioner that the subject lot had been mutated. Subject plot measuring 3 bighas, 2 kathas and 2 lesas had been mutated in favor of the petitioners and others also,
Yes, yes.
by an order dated 27/02/2022, passed by the Circle Officer, Palapa Revenue Circle, in mutation case number, paragraph 4. And consequently, and convert it. Full stop. No, full stop. In the process, the subject plot, which was under annual patta earlier, has been converted into periodic patta. Annual patta land has been converted into periodic patta land with DAG number 1627 and patta number 49, right?
Right. By here, my lord, converted, actually having patta number 307. Yes, no. 1627, patta number and tag number 49.
There are 4. Which such projections, the petitioners have claimed it. They have the status of a landholder under the Assam Land and Revenue Regulation 1886,
18.
insofar as the subject land is concerned.
Lordship, the vernacular portion, Lordship, is patta number is Lordship 749.
Huh?
Vernacular portion.
Vernacular.
Vernacular Lordship, Jamabandi copy page 27, Lordship.
Okay.
Patta number 749.
749. This is not legible. That is why it.
Lordship.
Yeah,
And they also translated as 49, Lordship.
Hmm?
They have translated as patta number 1627,
Tag
Lordship.
number 49, patta number 1627.
Translation part is also wrong, Lordship, page 26.
This is the problem for the court.
Lordship.
Everybody is careless,
They have translated,
leaving it to the court
DAG number is
to
49.
verify correctness. Patta number 40, DAG number 1627. Right hand portion,
Lordship.
page 27.
Lordship.
That was earlier. That was Exonia Patta. Now last line, see the remarks column.
Lordship.
3 বিঘা 2 কঠা 2 লেচা মাটি পৃথক 40 নম্বৰ পট্টা
Lordship. Lordship.
স্বয়ংসো ম্যাদীকৰণ কৰা হ'ল।
Now it's
Right.
now it's 40, Lordship.
49, patta number
Dag number 40.
49, my lord.
How can you read this
My lord,
as 40, 49?
49, my lord.
With my eyes, I see it as 40.
40, Lordship.
No, no, hey, it is not. My here is sir.
It's a 40 no.
And photo my lord. Now I got photograph and on zooming my lord, it is 49, my lord.
Huh?
49, my lord. 49.
40, Lordship, 40.
No idea.
40 or 49, I don't know it.
49, my lord.
49. 49.
ফোন নাই এটা ফোন নাই মানে গম পাইছি এটি হয় কোনো কিছু 49 পৃথক
The notices which have been served upon the petitioner by the respondent number 4 in his capacity as the estate officer from NF Railway, Rongia, state that the said notices are issued under subsection 1 and clause small b bracket small Roman 2 of subsection 2 of section 4 of the Public Premises within bracket Eviction of Unauthorized Occupants Act 1971 within bracket the Public Premises Act. Close. The notices have mentioned that in the notices, comma, the respondent number 4 has mentioned that he is of the opinion, comma, on the grounds specified therein that the petitioners are in unauthorized occupation of the public premises mentioned in the schedules therein, and they and the petitioners should be evicted from those public premises. Full stop. The grounds mentioned in the notices are similar, and the grounds are page 34, that's 1 to 3. That the lane in question is a railway lane, semicolon 2, that the petitioners are unauthorisedly occupying those lands, and that the railway authorities require the land for development work. Full stop. In the notices, comma, the description of the plots of land under alleged unauthorized occupation of the petitioners are shown as under petition number 1 or table banaই petition number 1 লিখি এই schedule লিখি দিব এনেকে প্ৰত্যেকটোতে বেলেগ বেলেগ schedule আছে টেবুলত দুটা কলম বনাই by the notices, comma, the estate officer NF Railway had called upon the petitioners to appear before him in person or through a duly authorized representative capable to answer all material questions connected with the matter, along with the evidence that the petitioners would intend to produce in support of showing cause at the time, date, and place mentioned therein. It has been further observed that if the petitioners fail to appear at the time, comma, date, and place scheduled, the case would be decided ex parte. So stop. On being served with the notices, comma, notices, dated, all dated 15 to 2024, the petitioners submitted a representative stating that the subject plot which is under their possession and occupation are is a land inherited by them. Full stop. The subject plot was earlier annual patta land, but in the year 2022, the state government has issued periodic patta in their favors, in their favor, and accordingly, their names have been mutated in the revenue records. Post of para. It is in the backdrop of above fact situation obtaining the case, the issue which has arisen as to whether this writ petition, the present writ petition filed under 226 of the Constitution of India is to be entertained or not. Full stop. Para. By on the basis of the records of rights within bracket, on the basis of the Jamabandi within bracket, records of right, the petitions have projected that they have a primacy case that they are landholders under the Assam Land and Revenue Regulation 1886. And as such, they are Land and Revenue Regulation, Land and Revenue Regulation. Land and Revenue Regulation. 2.1 নম্বর হব হব What is- and they are entitled to the rights under Section 9 of the Assam Land and Revenue Regulation 1886. Meaning thereby, they have permanent, heritable, and transferable right of the use and occupancy in respect of the subject land, subject to payment of all revenue, taxes, cesses, etc. from time to time, legally assessed. Post of para. On the other hand, comma, the railway authorities, responding railway authorities, through the respondent report, have laid claim in respect of the plots of land shown in the schedules of the so-called notices, comma, already indicated in the table here in above. Full stop. Para. Thus, comma, insofar as the descriptions of the plots of lands are concerned, comma, the lands in respect of which the petitioners have claimed their rights, the parcels of land, are at variance with the plots of land in respect of which the respondent railway authorities have claimed their rights on the premise that those parcels of lands are within our public premises. Presently, comma, the same has given rise to a disputed questions of fact. Disputed question of fact. Full stop. Para. Propose notice থাকিব premature বুলি ৰাখিব। Para. Propose notice premature বুলি ৰাখিব। The Public Premises Act is enacted to provide for eviction of unauthorized occupants from public premises and for certain incidental matters. Full stop. Section 2 within bracket E has provided for a definition of public premises. Full stop. Public premises inter alia includes any premises belonging to, comma, or taken on lease or requisitioned by, comma, or on behalf of the central government. Full stop. Section 3 has provided for the appointment of estate officers. Full stop. As per section 4, comma, as per subsection 1 of section 4, comma, if the estate officer has information that any person is in unauthorized occupation of any public premises and that he should be evicted, comma, the estate officer has to issue a notice in a manner therein provided, issue a notice in writing in the manner therein provided within 7 working days from the date of receipt the information regarding the unauthorized occupation, calling upon the person concerned to show cause why an order of eviction should not be made. Full stop. Under subsection 1A, as per subsection 1, comma, applicable. As per subsection 2, comma, not notice shall A, specify the grounds on which the order of eviction is proposed to be made, semicolon, and B, require all persons concerned, comma, that is to say, comma, all persons who are or may be, comma, in occupation of, comma, or claim interest in, comma, in the public premises. 1 to show cause, comma, if any, against the proposed order on or before such date as is specified in a notice, comma, being a date not later than 7 days from the date of issue thereof, semicolon, and B, Roman 2, to appear before the estate officer on the date specified in a notice, along with the evidence which they intend to produce in support of the cause shown, semicolon, comma, and also for personal hearing, comma, if such hearing is desired. Full stop. Subsection 3 requires the estate officer to cause the notice to be served in the manner mentioned herein. Full stop. Para. Subsection 1 of section 5 has provided for the procedure to be followed by the estate officer after considering the causes shown by the person who has been served with a notice under section 4 and the evidence produced before him. Full stop. As per subsection 1. Liquidable. Para. Apparently. Okay. Under the, well, not under the, no. Rule 4 of the public premises within bracket eviction of unauthorized occupants, bracket close, rules 1971, comma, framed under section 18 of the Public Premises Act 1971, has provided for the manner of service of notices and orders. Full stop. Rule 5 thereof has provided for holding of inquiries, full stop, as per sub-rule 1 of Rule 5, comma, where any person on whom a notice or order under the Public Premises Act has been served desires to be heard through his representative, he should authorize such representative in writing. Full stop. Sub-rule 2 of Rule 5 has cast an obligation on the estate officer to record the summary of the evidence tendered before him. Full stop. The summary of such evidence and any relevant documents filed before him shall form part of the records of the proceedings. Full stop. It is pertinent to note that any order passed by an estate officer under Section 5 of the Public Premises Act 1971 is an appealable order under Section 9 of the Act. Full stop. Para. It has been held by the Honorable Supreme Court of India in New India Assurance Company versus Nusli, Neville, Wadia, and another, comma, reported in 2008, 3 SSC 279, comma, that the action of the state in the capacity of the landlord, action of the state or its instrumentalities or an instrumentality of the state within the meaning of Article 12 of the Constitution of India in its capacity as a landlord, comma, must be fair and reasonable. Full stop. The action of the state in terms of the Public Premises Act should not be arbitrary, comma, unreasonable or malafide. Full stop. The estate officer, being a creature of the statute, must adhere to the prescriptions of the Public Premises Act. Full stop. It has been observed that the statute, comma, although, comma, does not require a lengthy hearing or a lengthy cross-examination, but the notices should be given an opportunity to file an effective show cause. Full stop. An effective show cause can be filed when eviction is sought for a specified ground and the occupants must know the particulars in relation thereto. It has been further observed that the provisions of the Code of Civil Procedure and the Evidence Act are not applicable, not applicable, but the principles of natural justice must be complied with, must be followed. Full stop. When in support of its case, the landlord intends to rely upon a document which is to be taken on record, it would be obligatory on the part of the estate officer to allow inspection thereof to the noticee. Full stop. Denial of such inspection of documents shall be violative of the principles of natural justice. Full stop. It would run counter to the doctrine of fairness in a matter of determination of a lease between the parties. Paragraph 47. Full stop. As it primarily appears that the petitioners claim regarding their status as landholders in respect of the subject plot is against the plots of land mentioned in the schedules to the notices would fall for consideration of the estate officer. The following observations made in Nusli Neville Wadia Supra appears opposite, paragraph 49 and 50. For this court, in view of from the discussion, in view of the discussion, as the petitioners have a have a participatory right in the proceedings initiated by the estate officer in April week. While the notices dated 15/2/2024 and Section 4 of the Public Premises Act in the proceedings before him, and they have the right to lead evidence in support of their claim regarding status of landholder in respect of the subject land, the present writ petition. And the estate officer is under obligation to decide the proceedings by following the principles of natural justice, including affording of opportunities of hearing to the petitioners in a fair and impartial manner, and only on the basis of the summary of evidence recorded by him recording the proceedings, the writ petition is found to be a premature one. Any order to be passed by the estate officer under section 5 of the Public Premises Act is appealable under section 9 of the Public Premises Act before the jurisdictional district judge.
Lordship, sir.
Full stop. Hello. In view of the sorry. It is however made clear that premature, in such view of the matter, the writ petition is not entered in because writ petition is not entered in because the petitions have approached this court at a premature stage.
Only my lord, only fair opportunity, my lord. The estate officer, my lord, while
I have quoted
Very low,
my-
sir.
from the judgment.
my lord,
I have quoted from the judgment
my lord,
that it is not only you, he should also lead evidence.
my lord,
Railway, that plot is there.
my lord.
Otherwise, they should also, they cannot escape from leading evidence. You lead evidence regarding your patta, they will lead evidence regarding their land. And thereafter, it is district judge, he is there. But you have to lead evidence properly.
Yes, my
And if he refuses, then again, you know, Mr. Hawk is there.
My lord.
Oblige, lordship.
Oblige.
Release for admission item numbers 1 and 2.
See this respect of, in respect of 7220, item number, Lordship, order is initially by the order of 28/6/2022.
28.
28/6/2022, because everything was decided
Yes.
by, and the point was this,
Okay, a few documents were asked for.
yes, so that everything is,
Then affidavit was filed.
yes.
Then
Letter
thereafter,
14 was
another observation was made. Detail order
detail order,
and
yes, detail
asking
order,
Mr.
everything.
Barbuzai to file an affidavit.
Yes, because the National Highway said that they submitted also affidavit, they say that they are not liable to pay any amount. And it will,
So you have to file an affidavit.
and
This court is of the opinion that it will be in the interest of justice. Do you have the order?
No, here, my lord.
Whatever. You've been directed to file an affidavit.
Directed to file an affidavit. Now, here, my lord, the admitted position. The admitted position is that, my lord, in both these writ petitions, part and parcels of plot of land were acquired under the 1894 Act. Now, that acquisition proceedings got lapsed. Now, my lord,
That we will decide.
yes,
Leave it to us.
no, my lord, now here, my lord, who will pay the money? This is now the issue. Because,
No, this is not the issue. The issue is one, at least, you have been asked to file an affidavit
yes,
by an order dated 14/11/2022. That is
Yes.
clear. We are in 2024.
24.
That is also clear.
so one affidavit.
Don't go. Let us stick to that.
Yes,
In the meantime, the respondent authorities shall apprise this court as regards their intention by filing an affidavit. That is clear.
That is all.
What more clarity is required?
Yes.
Filing of affidavit request from the authority, right?
yes, my lord. Lordship is, my lord, drawing attention to order dated 14/11/22.
Ah.
Yes, ma'am. After, my lord, 14/11/22, affidavit has not.
No, it is not there.
No, no, nothing, nothing.
Looking at the file will not do because there is nothing.
nothing.
Because we have communicated to the department, my lord, but instructions are not forthcoming.
We are about 9 years.
Yes, yes.
We'll celebrate a decade. We'll celebrate a decade.
After 14/11/22, my lord, the next date was fixed on 19/1/23. We have duly communicated. No, my lord, that affidavit will be filed, my lord, but
Because consequence may be,
no, here, my
consequence
lord,
may be very high, right?
very high.
So
Now, my
we,
lord,
court doesn't want to put the burden on Warpuzari.
my- but my lord, it is my bounden duty, my lord, with all humility, my lord. My lord, these two writ petitions, my lord, let me, my lord, I'm submitting, my lord. My lord, the admitted position, yes, we will of course file an affidavit, but the admitted position is that, my lord, that the earlier proceedings got lapsed. And so far as the writ petition, my lord, Lidu Tea Company is concerned, they got some money. And my lord, so far as the second writ petition, Odhigrohon Koriba Bisara Dabi Committee, those people have not got any money. Now, my lord, so far as the second writ petition is concerned, the part and parcels of land involved in the second writ petition, those were, my lord, acquired in papers, but possession still remains, my lord, with the petitioners in the second writ petition. Under that circumstances, my lord, an affidavit has come, my lord, from the NHIDCL. NHIDCL say, my lord, that they are not liable to pay the money. Now the question arises, my lord, who is going to pay the money? Because the revenue authorities are only the facilitating agencies. It is the.
So that is why
Yes.
that your sequence of events, firstly, we, after hearing all the counsels,
Yes, yes.
that we thought it fit on 28/6/2022, that let us have this gazettes publication and all this. And thereafter, that was brought by an affidavit. Then detailed order has been passed after going through all the documents.
Yes.
Because your case will be based on all these gazette notifications, compliance of section 4, section 5A and section 6. And you do it section 17, 11, 12, right? Almost something have been observed,
My lord.
right? Not the final arrival of final destination, but prima facie view
Yes,
has been expressed.
that's great. Yes.
It appears like something like that, that a horse should be before the cart, but the cart is before the horse.
Yes, lordship, yes,
No,
right.
okay, the same proverb
Horse
was
should
good.
be before the cart, but cart is before the horse. Like that. Some observation. So that is why that if you do not want, since they are possessing, suppose they are possessing the lands, nobody has taken over possession, then there is observation made that whether they would like to retain the land,
yes,
Or
then in that case, they will get back their land. right? You say no, they will get back their land. You have been relieved of the responsibility
Yeah.
of paying any revenue. Is it not? That is one. Secondly, the other part, the company. So that is why court has,
some instruction bunch of papers we have received, but it is my lord, it says my lord that NHIDCL has taken over possession.
and what
Their-
is this then?
Their stand is that my lord, they are not liable to pay the money.
They
say-
say.
Anyway, we will not divert from the direction given by the court.
Yes, yes.
If you say no,
Yeah.
then Mr. Sharma will be benefited, they will retain their land. If you say also, he will be benefited, they will get money. Ms. Chopar, B. Sharma is concerned, will decide on the basis of affidavit.
Yes.
I will file an affidavit on
I think better.
the instructions that I have, because I have not
No,
chosen
no,
to-
clarifying the government, it is government.
government, yes. The
To
government-
take a position as to whether they would like to retain the land by paying compensation in terms of so and so, or to give up the claims in respect of the land.
Yes, now my instruction says, my lord, my instruction, it appears that the possession of the aforesaid land is presently with National Highways and Infrastructure Development Corporation Limited. They have negated. Under those circumstances, my lord, I was seeking, my lord, some, my lord, further instructions from the department. Nonetheless, my lord, on the strength of what instructions I have, my lord, pursuant to order dated 14/11/2022, I will bring on record, madam.
Whether that will answer the question.
That will answer the question, but there will be a contradiction between the stand of
No,
the.
who is the responsible authority who has provided you the comment? Circle officer,
No, my lord, the revenue department.
revenue department.
They have taken inputs from the deputy commissioner at Inchuk.
Ah,
On the
better.
strength of the input, because this is the, my lord, immediate authority, collector.
Hmm.
So collect from the collector, my lord, this is inputs they have derived it and they have, my lord, furnished it to us. So that
So-
is the difficulty. Otherwise, I will file an affidavit. Lordship may kindly peruse some, my lord, lordship will get some. Because all those gadgets notification and all those documents, they are, those things are available. Those instructions are, my lord, dated 3rd of March 2023. Thereafter, my lord, the NHIDCL has filed an affidavit on 17th of July 2023. In their affidavit, my lord, what they have stated, my lord, at paragraph number 5, my lord, I am reading it, my lord, it is on record, my lord. In both the cases, they have filed affidavit. Development of bypass will be taken by NHIDCL. Therefore, the land acquired by the state government and possessed over by the executive engineer PWD Dibrugarh has been handed over to NHIDCL by the Kala Tinsukia, right? So and so, like two. The total land handed over to comprises of 70.26 hectares, namely so and so. It has been stated here that at the time of transfer of the acquired land, no condition for payment of land acquisition was intimated, and also no information about any application or anything pertaining to compensation of the transferred land was brought to the notice of the NHIDCL by the Kala, Tinsukia. It is further to mention here that as per extant guideline of the Ministry of Road Transport and Highways, New Delhi, the land vesting in central oblique state government is transferred to central oblique MOT free of cost for construction development of NH without any liability. Since the land is acquired is the government land and has been transferred to NHIDCL subsequently, the NHIDCL is not liable to pay any cost or compensation in respect of land acquisition, and the same is duly informed to Kala by the office of the deponent so and so by letter dated 16/1/2023. Now, the factual matrix involved in the case, my lord, boils down to the fact, my lord, that the land was acquired at the instance of PWD. At the instance of PWD, and PWD is not a party respondents out here in both the.
No, we are meant for compensation. We are meant for compensation.
Yes.
Interdepartmental,
Internet.
we are not here
That is also decided.
after 9 years.
That is also decided.
We're not interested on that aspect. So
But-
PWD not party, 9 years you have taken to raise this issue.
No, my lord, since NH.
No, I don't know that. You raise on this issue by pleading. By pleading, you have raised all this issue
No,
during these 9 years.
No.
No, don't make. I don't think this is
yes. No, since-
proper at this stage.
No, therefore, my lord, since NHIDCL now has filed an affidavit, so my lord, we will be filing an affidavit on the strength of those instructions. There will be.
No, you only stick to this. Because it is state or central. We are concerned with state or central. You stick
Central
to
government-
this, notification,
Yes,
sorry, or direction,
yes,
file it and affidavit.
my lord.
I think we should retread this, otherwise again we lost track.
Yes, Lordship. Because
Ah.
so many orders have been passed, Lordship. In my case, Lordship, last occasion also decided 2 years back that this 72 can be disposed of right now, but because of now the matter is pending. Part payment is done as per new act, that has been proved. As per the, so the, as per new act and the interest. And they say in other case also, Honorable Justice Devasi Broja, it is burden upon the government unless to pay the interest for this delay part. Section 80. In my case, that is also there because the pendency of they have not filed, not the dispose the taking effort to dispose the matter at the earliest, then who will pay that interest part later on? That burden will also be there.
Okay, heard Mr. B. Sharma, learned counsel for the petitioner, 28/6/2022 order. B. Sharma in 7/20/2015. Mr. A.K. Sharma, learned counsel for the petitioners in WPC 1586/2015. Mr. R. Borpuzari, learned standing counsel, Revenue Department. And who are for the state? Mr. B.J. Talukdar, senior counsel, assisted by Mr. P. Medhi, P.K. Medhi, learned panel lawyer for the other state respondents, and Mr. Tien, other state respondent,
Right.
and Mr. R. A.
Talukdar, my lord, for
Talukdar,
NHIDC.
standing counsel, NHIDC.
Lordship, in this case, Lordship, competent authority is required, Lordship. In this case, PWD department is the acquiring agency, Lordship. In Lordship,
With, after 9 years, I have not got. State is there. State is there. Nobody, you raise this question verbally.
Lordship, NHIDCL has met party subsequently, my lord. That is why, Lordship.
Finding proper, we have implemented by our order.
Union of India
At
is
this
also,
stage, we do not find any necessity to implement.
Union of India is also a party respondent, my lord. They have chosen not to file any affidavit.
This court on 28/6/2022. Sorry, now, had passed an order, the relevant excerpts are quoted herein. Para. In deference to the order dated 28/6/2022. Comma. An additional affidavit was filed page 70. Filed by the respondent number 3 in WPC number 7220/2015. That is the deputy commission. Tinsukia. On in August 2022. Chinmoy. No. Respondent number 3. Yeah.
It will be say additional verification.
Respondent number 3. An additional affidavits on behalf of the state respondents. Full stop. After perusal of the materials brought through such additional affidavits. In respect of the land acquisition cases. Command that is LA case number 32/2009, LA case number 33/2009, LA case number 35/2009, LA case number 36/2009, LA case number 37 or 44. Now 32, 33, 35, 36, 37, and 44. The court, this court, in its order dated 14/11/2020, had observed as under pencil to pencil. Mr. Borpujari. Land standing also Revenue Department has sought.
Will kindly grant me 3 weeks time.
Huh?
3 weeks time, my lord.
Lordship,
Because
only one submission, because 14/11/2002, that was the given to take instructions. Today is 2024 May. But sir, it is a date kindly be fixed 2 weeks, at least giving a date, and that should be the last chance only for final, because 2015 we are suffering on
Do.
this.
File an additional affidavit in terms of the in reference to the order dated 14/11/2020 has sought for 3 weeks time. The prayer made on behalf of the by Mr. Borpujari and so is allowed. List the cases on
12/6, 12 June. 12 June, yes, Lordship.
12.
12
or,
6.
yes, Mr.
My lord, can it be on, my lord, 18th of June, my lord, if not in
Okay.
18th?
Okay, 18 is.
Reasonable enough.
Yes,
Election is there, results is there.
But Lordship, can it be, make it a part hard, Lordship, because
I don't know where I'll be.
even though,
Yeah,
Lordship.
that is
because
too long a date.
so many times that.
But
So the, and the last chance, that has to be added because so many days, time.
they
has-
have also difficulties. All of them
And
have.
Lordship, that, only that is required, that
I have
affidavit,
fixed the date already. Let us
the date is, affidavit is to be filed separately into, because my case is completely not relevant with their case. So that affidavit should become separate.
I have quoted the entire order,
Yes.
1411,
Yes, yes, yes. Sir.
for the purpose of facilitating Mr. Barpuzai to obtain instructions and to file affidavit. A copy of this order be supplied to Mr.
I will
Barpuzai.
submit it immediately, my lord.
No, we'll record.
Yes, yes.
But
Okay,
the
okay.
difficulty is that, my lord, I had these instructions, my lord, but in the meantime, since, my lord, thus after 1 month of having these instructions, my lord, this affidavit has come from NHRDCL.
Aspect is
Yeah.
highlighted or not, court has expressed a
Yes,
view
yes,
on two
yes.
matters,
Yes, my lord.
two issues. That
Since, my lord, part and parcels of lands.
if
are,
you
my
don't
lord,
require the land, okay.
I will file my.
If they are enjoying possession till date, okay.
But my garden has been
No,
bifurcated.
that is different issue, but so far as Sharma's
Yes,
client
yes,
is
yes.
concerned, if they are saying that they don't require, then don't require.
Yes.
This is one of the case, my lord, where I am finding it very difficult, my lord. Anyway, my lord, I will file an affidavit, my lord.
Nice.
I'm so obliged.
Item number 3.
It will engage. Oh, it will. Okay. Your, yes. Huh? ছিল না একটু আব্দুল রফিক নাকি রফিক রফিক শ্যামবাবু Okay.
The copy of the judgment of Noyanmani case, I have enclosed in my reply to the affidavit filed by the opposition on 12/2/2024.
Okay, we'll let us record the facts.
Yes, the huh? Facts. But the petitioner, he was working as a driver on contextual basis in industry.
Otherwise, you appeared in a selection process
Yes,
meant for peon.
yes.
So you
Oh.
should continue with peon.
But that is what happened at the time, the Anil Boisho, who was the driver of the industrial.
He was under suspension. The
Suspension.
presiding officer had appointed you in the post of driver. That is erroneous. Then after when reverted back, you were given pay protection.
Protections.
That is all.
Yes, that. And the.
Noyanmani Sharma was
petitioner-
initially terminated perhaps, but sought to be terminated.
Yeah.
But because one man asked for voluntary appointment, somehow the situation was saved. That Noyanmani was appointed in that. Otherwise, he was second in the select list. That is all.
No, I was in the first post.
Right.
I'm right, first. Noyanmani was second.
Second.
When I was appointed in the post of driver, Noyanmani was appointed in my post.
Okay, that I have taken note of.
So when Anil Boisho was reinstated by the High Court in 2014, then he was appointed.
Now,
to-
question is about recovery of the amount
Yeah.
which were granted to you during the interim period till your reversion to the post of peon by that order pay protection, which appears to be erroneous, but there is no fault apparently on your part. It was the fault on the part of the presiding officer.
Yes.
That is all.
Yes.
That is all.
There is no fault on my end.
So no recovery.
Yeah.
That is your case.
Yes,
That is your case.
yes, my lord.
Yes.
I have submitted.
His case is no recovery
Fine, my lord. So far as, my lord, the pay fixation.
for the period.
Recovery is, I am all right, my lord. But his pay has to be on the post of peon.
Yeah, this.
That cannot be driver.
Oh, that cannot be. He
What
was,
judgment?
He was appointed by the authority, my lord.
right, but otherwise the advertisement was peon.
Peon. But their contention is that I should have refused. Why I refused? I'm getting the job. If I'm given appointment in the post of peon, why I should? That is their contention. that I should have
Unnecessary
refused.
contention raised.
My lord, it is my lord, the
Ah.
present.
If one asked for a license of a revolver, but the authority chooses to give him rifle for AK-47, he will happily accept. Why not? Right, Mr. Das?
Yes.
There is no fault on the part of the petitioner, my lord. Supreme Court judgment is very clear, my lord.
Which paragraph, Mr. Das?
Para 14, my lord, is the operative portion, but facts, my lord, will find para 2, 3, 5, 6.
2,
Yes, my lord.
3.
2, 3, 4 also, my lord. 4, 5,
Four.
6 are the facts.
Facts.
Yes.
Hmm.
Herein also identical situation, my lord. He
Let
was,
me read then. Let me read.
yes, my lord. I'm sorry.
Curious, my lord. Curious from the way they it was state orders.
So far pay protection is concerned, I don't think you have any right.
My lord,
Protection,
yes,
only recovery.
yes.
Oh, we are on recovery. Pay protection, no.
No, he is not, it is not liable to be recovered, my lord. Because I have given service for during the period I am
No,
giving
no.
service, I am paying.
No, I am saying that pay protection you are not entitled to.
Yes,
But so far as recovery is concerned, yes, that should not be recovered. What has been paid already should not be recovered.
it should not be recovered and it was, now he is doing till today. Till today, he is, because the matter was stayed on the way day of the motion, my lord. Because it is not recovered. He is doing till today that scam. Today he will continue till retirement, my lord. The protection is given. Moreover, one thing, my lord, the present presiding officer,
What is the interim order?
one thing may kindly be heard, my lord. The present presiding, he is not the appellate authority. A order is passed by his predecessor. Order passed by the predecessor is binding on the successor, my lord. Successor office. He is not the appellate authority, my lord, to reverse the order passed by his predecessor, my lord. It is prima facie legal, the order is. Moreover, the part of the income order I said aside so far as non-one is concerned.
What is the meaning and purport of the interim order?
Recovery is state, my lord.
No.
Existing benefit
the
cannot be
petitioner is
lowered down, my
concerned.
lord. In case of government employee,
recovery
there
is
is no fault on his part.
It
It is the existing benefit that has.
has been stayed. 37, 2017. Hmm. By prolonging the interim order,
My lord,
page
My
35.
page 29.
Lordship will decide the issue. The issue is, one aspect is that, my lord, recovery. So far as recovery is concerned, there is no doubt about the proposition of law.
No, yes, no
Yes.
problem, the recovery, but by virtue of the interim order
Yes,
that he has been enjoying
yes.
the pay with pay protection till date.
This period also within.
Till
will come
today,
within
till
the.
today, he has been enjoying the salary with pay protection by
Perhaps,
virtue of the interim order.
True.
Right. But now if we find that pay protection order is not correct, pay protection order is not correct because he was selected for the post of peon. Erroneously or by whatever
Right.
of the presiding officer, he was given pay protection when he was reverted back to the post of peon. And that continued till date. So recovery of the amount, higher amount till date,
Lordship is correct.
that is substantial amount. Now it is not possible also on his part.
Yes, ma'am.
And so the interim order will merge with the final order.
Yes,
Then interim order will stand modified so far as recovery is concerned. So far as pay protection is concerned, I don't think he has any legal right
yes,
to have the pay protection of driver
yes,
by serving in the post of peon.
yes.
That the existing benefit cannot be cut down. That is the principle, my lord. When a government employee is doing a particular.
No, you are
is-
peon, Mr. Sharma, you are not driver. But by virtue of interim order,
I have been.
you
doing-
have been enjoying the pay protection order, but on the face of it, this pay protection order appears to be not sustainable in law. Question is recovery. So far as recovery is concerned, we
Pay
can
protection,
think of
that pay.
not non-recovery. But so far as pay protection is concerned, which appears to be privacy,
On this strength of pay protection, he is doing it, doing that skill till today, my lord.
right?
Interim order is
There
there,
are
my
two
lord.
parts to it.
Hmm.
One is we have to decide whether this pay protection order is correct or not. Right? Pay protection order.
Not others, my lord. But it is, my lord, the principle is there when a government servant doing a particular pay scale.
You are
it cannot be
driving
cut.
cars.
It cannot be cut down.
You are driving cars or peon?
The peon I was.
No, please tell me. Since 2007,
2006.
no, we are on 2017. 17. After that order, that interim order, it has been stayed. So you are working as a driver presently, or you are working as a peon?
Since 2014, I am working as a driver.
My lord, may I subject to
2014.
correction, my lord, subject to correction. In the affidavit reply filed by the petitioner, therein, my lord, he stated working as peon in the establishment of labor code,
Which paragraph?
page 44.
And what about
My lord, may I cross check this, my lord? Perhaps this is required,
which one?
whether he is working as peon or driver.
Right.
Otherwise, my lord, it will have serious bearing. But because if we go prima facie see, in his affidavit, he says, Sri so-and-so working as peon in the establishment of labor code. In the latest one.
What is a version of the
Filed on 12/2/24.
your stand?
I stand, it's not clear whether the,
Yesterday, at present, he was.
No. 1 minute, one more exercise to be done.
yes,
Come to page 21. This order is not stayed. Page 21.
In the interest of power.
no,
So he is working as peon,
he is working.
enjoying the scale of
Yes,
driver. Enjoying the skill of driver. That is not stayed.
that is not
What is stayed is
the recovery.
recovery.
Yes,
That is not stayed.
that is not safe.
Then because of that, Royan money was sought to be terminated.
Yes,
Fortunately, one person opted for voluntary retirement.
yes.
In that post,
Yeah.
Royan money was adjusted. I think that is the situation.
Yes,
So he was reverted back to the post of peon
yes,
in 2014 itself
yes,
with the reinstatement of that Anil Vaishya.
yes,
See page 20 order.
yes, my lord, I have seen.
So he has been working in the post reverted back after reversion, working as peon, post of peon,
Yes,
but enjoying, where is the pay protection order?
There's an evening order.
Same page.
in
with
that
pay
page
protection.
21 itself, it was written.
Pay protection. So there are two parts to it. Page 21. If I am not wrong, that by this order, he has been reverted back and he has been given pay protection. So as a result, he has been working as peon, but enjoying the
Pay of the
scale of
driver.
driver. Thereafter, he joined, page 22. He joined. Then page 24. Some money sanction is accorded, area pay and allowances. Then this show cause notice. This show cause notice that you are enjoying pay protection.
So cause notice was issued by the registrar. He is not authorized to do.
Whatever. But only issue raised here is why excess payment received by him as pay protection should not be taken back. That is the only issue.
Yes.
Show cause, come to page 25.
I am thinking about only one question, my lord. After the interim order, recovery is all right. Because there are two aspects. One is recovery and actually what pay he was getting. Whether he was given the pay of peon or driver in this interim period.
He was taking a pay. scale of
Recovery is
Driver,
all right. Recovery is all right.
Driver. Enjoying driver. But he is discharging duties of peon.
Hmm.
Pay protection he is entitled. Existing benefit cannot be cut down.
After the impugn order, whether he was given the pay of peon or the driver. I'm
Right,
not
right.
prior to that, my lord. Because he approached this honorable court. This honorable court passed an interim order, stay and recovery. My lord, I'm submitting about what actually happened in the labor court, my lord. That instruction, if I can take short date, what happened actually? If he is till date, he is enjoying the pay scale of driver,
Right, right.
then things will be different. The order also perhaps would be different.
After
That is,
interim
he
order,
is
he is
enjoying driver.
My lord,
Salaries of driver.
Yeah.
Come to page 25,
Yes.
read.
Based on the pay protection.
We'll come back. That's
Yes,
after
much.
This is a so cause, page 25.
Yes, my lord.
His reply. And then what is the
I'll-
final order?
Page 35, my lord. That's what I am also discussing with my senior friend. Page 35 order has got two parts, my lord.
First part is that appointment of Dimbeswar Deka on 30/10/2006 be treated as an appointment in the post of peon in the office of the so and so. That is one part.
No, and his pay scale, that is one part. Up to full stop, perhaps.
Hmm.
And his pay scale as per ROP old to be refixed from the date of appointment. So he'll be treated as appointed as peon. And from 30/10/2006, his pay scale will be refixed in the post of peon.
And second part is excess salary.
Recovery.
So far as the first part is concerned, refixation of his salary. But first part also contains two parts.
First part also contains two parts. One is to the post of peon and refixation
Hmm.
in the post of peon, refixation of pay.
As a result, of the second part was made. And
Yes,
second part was made more complicated with the interim order.
yes. Normally, recovery.
Normally, had it been that so far as,
Yes,
but interim order is that
the entire order is stayed, was stayed.
Was state. Now we have to test the validity of both the parts
Yes,
along with the interim order, consequence going out of the interim order. Interim order is that shall remain state so far as the petitioner is concerned, and no recovery shall be affected from the petitioner until further orders. So as a result, that reversion to the post of peon had happened in 2014,
yes,
but with a pay protection.
yes,
Discharging duties of peon since 2014, but enjoying the scale of driver
driver,
since 2014.
Yes.
From the beginning,
yes,
as well as on and from 2014.
yes,
Continuing, my lord.
It continued till the impugn order, and by virtue of the interim order, it again continued
yes,
the case. So the recovery is till the date of decision, but
yes,
in the writ petition to be decided, he is enjoying till date the higher salary and allowances. Now, that is by virtue of court order.
But my lord, the part of the.
One is recovery till 2017, till the date of impugn order, and thereafter by virtue of the interim order till date. So refixation is one thing, because he appeared for the post of peon
yes,
and must be appointed to the post of peon.
peon. The entire
That order 2014, his reversion has not been challenged.
no,
But the pay protection part, which was sought to be taken away by the impugn order, that has been challenged. Is it not?
My lord, the
I think that is the actual matrix.
yes, my lord. Fact-
Money judgment, my lord, there is the observation that he is appointed regularly. By this order, the part of the improvement order is already set aside. The normally judgment I have annexed in my additional affidavit 12/2/2014, page 51, my lord. Here, my lord, para 9, para 9 may can be seen, my lord.
Which he was otherwise entitled.
Para 9, page 57. In any view of the matter, I do not find the applicability of the provision of Umadevi case supra. In fact, the circumstance of the case in as much as the person was appointed after due selection process and against the valid sanction post. And whenever discrepancy has happened in appointing the respondent for against the post of the driver later on, when the post of the driver became unavailable, as the same was
Irregularity is committed by the appointing authorities.
Because of irregularities committed by the appointing authorities themselves, it is no fault on the part of the petitioner, my lord. So pay
Situation has
protection-
become more complicated with a stay order.
Yes,
Anyway, otherwise,
When a government servant is receiving any pay scale, that cannot be cut down, my lord. That cannot, because of any fault, without any fault on the part of the
no, that
employee,
is,
it cannot be
but
cut down.
otherwise you are not entitled.
No, because I am continuing myself. I am continuing my.
Till that you are continuing
Pay
enjoying the
protection-
scale.
Pay protection can be given by the authority, my lord. Authority can give a pay protection because his certain pay scale has been growing. If he is given other pay scale, then he has to
No,
lost something.
there is another part to it.
That loss cannot be
No,
made.
my
there
lord
is
can do,
another
my
part
lord-
to it.
Lordships can do one thing, my lord.
There is another part to it, that pay scale is attached with a particular post. And that is legislatively fixed.
That is the concept of pay protection, my lord. The scale does not go pay protection when an employee is getting a pay scale. If it is saying he has come to another post, that protection has to be given because it cannot be lowered down. What scale he is getting, it cannot be lowered down. That protection should be given.
Yes, Mr. Das.
My lord, because the impugn order says that his pay will be refixed from 30/10/2006 in the post of peons. That can be done, but no recovery till date. Because that is legally correct. He is a peon from 30/10/2006, my lord. So his pay will be refixed on that day, but no recovery. I think that will suffice the petitioner's purpose also.
Because regarding pay protection, if your lordship want, I will submit decision, I will be given a date, my lord.
Okay, I'll look into it.
Pay protection has to be given to an employee when he is continuing in his job.
Because court's order should not prejudice anybody. That is.
Moreover, the whole thing is illegal, matter. He is not the appellate authority. Present presiding officer, he is not the appellate. When an order is passed by his predecessor, it must be binding on the successor in office, my lord. His successor in office, he cannot review his predecessor order because he is not the appellate authority, my lord. The so-called notice was issued by the registrar. The registrar is nothing but a head clerk in the office of the labor court, my lord. So head clerk cannot issue so-called notice, my lord. There are so many infirmities, my lord, in this order. He acted like an appellate authority, my lord. Order passed by the predecessor, he reviewed, said aside all this, my lord. That cannot be done. That is nothing but a harassment on the part of the post petitioner, my lord. The court get he's sincerely doing his duty, he's given services, driver, thereafter as peon. The pay protection is the principle, and that has to be
There is
given.
one issue, where is the rules?
Rules, I'll have to, my lord.
What are the rules governing the employees of regulating the service conditions of labor code? Any idea? Whether you have raised this point? That this so-called notice is without jurisdiction?
That observation is made in earlier judgment, the Noel Money judgment, my lord.
No.
Which
The-
one? Which paragraph? No, no. Have you, is it your pleaded case? Is it your pleaded case? See, that is another question,
No.
Mr. Das.
My lord, I don't find any pleadings against respondent number 5.
That order passed by the presiding officer Rita Bora. Thereafter it was by some Pritam Soit,
Huh?
my lord. Pritam Bora.
Oh, that has a presiding officer.
Yes,
How can this page 35, it is passed by presiding officer,
that order passed by presiding officer.
right?
Earlier so-called notice was
Ah,
passed by the
that-
registrar. Registrar.
That, whether that
my-
issue is raised, no, in your reply, that is not raised.
Even presiding officer is concerned, I am
But
submitting
that
there.
locus is not even
He-
challenged.
He is not the appellate authority, my lord.
No, no,
His successor in office, my lord. Successor in office cannot set aside or review
that,
the order
that,
passed by
that
predecessor, my lord.
proposition, I don't
Huh.
feel it is sustainable.
That he cannot do, my
That
lord.
that is by a so-called notice. And whether he is the appointing authority or not,
My lord.
whether he is the appointing authority or not,
He is appointing authority.
right?
But his order passed by predecessor, my lord. Predecessor in office, he cannot do it. Anyhow, the non-money was terminated on the ground that he was appointed without an interview. So that has been set aside already. Part of the impugn order is set aside.
So why you are not, bringing non-money every time?
Same order, same impugn order,
No, Mohanwell case is different.
same impugn order.
There is a difference.
By same order, non-money was terminated and he was ordered to be recovery.
Which or judgment? 1994?
1994.
Huh.
Here the category rule has been laid down, page para 18, my lord. Under what circumstances
Huh?
cannot be cut down.
Para 18?
Para 18 of the judgment.
Which judgment? Which judgment?
94 judgment. Sorry, 2015 judgment. 15. 15 judgment.
Para?
Right, it is not possible to postulate all situations of hardship which would govern employees on the issue of recovery when payments have mistakenly been made by the employer in excess of their entitlement, be that as it may, based on the decision referred to herein above, we may as ready references summarize the following few situations wherein the recovery by the employees would be impermissible in law. First, the recovery from the employees belonging to class 3rd and class 4. My petitioner is class 4 employee. The recovery from the retired employees or the employees who are due to retire within 1 year of the order of recovery. The recovery from the employees when the excess payment has been made for a period in excess of 5 years before the order of recovery is passed. যদি if it exceeds 5 years, that cannot be recovered.
No, I am not on that.
Well, here 11 years.
I am only that after consequences flowing out of the interim order. That is what I'm.
Here, my lord, it became the 18 years. From the interim order, also it became 5 years over.
The consequences flowing
So-
out of the interim order.
The
That is what.
recovery of
Yes,
the
I have
cash when an
That
employee has
section which you have said, that is the maxim. That is what I am on.
Yes. But if the pay fixation is upheld, and at the same time, recovery, whatever he's drawn till today, by virtue of the interim order,
Mm.
is protected, I think both the purpose will be served. Because otherwise, then
Money has already gone out of the state exchequer.
that's true.
So recovery at this stage will be harsh. Be that by interim order, whatever. So that proposition,
so my case is covered by judicial madam.
Because if the pay fixation
Recovery
is
of cases of an employee,
interfered,
no,
then
Mr. Sharma, the recovery part, we are not in doubt.
recovery even after his appointment as pure my lord. It will also,
It is also not in doubt that you are discharging duties of peon since 2014,
beyond but it was.
enjoying
was
pay
given-
protection.
This was stated by the earlier interim order. It is enjoying until today. Even after beyond 5 years. This ruling has said that beyond 5 years he cannot be recovered. And then it is 94 Supreme Court, page 521. The higher pay scale erroneously given to petitioner since 1973. Pay scale of the petitioner reduced in 1984. Held since the petitioner received the higher pay scale due to no fault on their part, it shall not only be just and proper to recover any excess amount already paid to them. My lord. It is 94 Supreme Court, my lord. So maybe erroneously given, but he is not responsible for it. Para 11, although we have held that the petitioners are entitled only to the pay scale of 330 in terms of the recommendations of the third pay commission with effect from 1970, and only after the period of 10 years, they became entitled to pay scale of 330. earlier he has grown before it become mature. 336, but they have received the pay scale of 335, 60 since 1970 due to no fault on their part, and that pay scale being reduced in the year 1984 and effect from January 1, 1973. It shall only be just and proper not to recover in excess amount which has already been paid to them. Accordingly, we direct that no step should be taken to recover or to adjust any excess amount. Amount paid to the petitioner due to no fault of the respondent, the petitioner being in no way responsible for the same.
As a restriction, his salary will come down drastically.
The revised pay of peon is 2450-3670 and driver was 2650-5200.
So whatever because of interim order he has enjoyed
Yes, ma'am.
till date,
Yes.
let him enjoy. But so far as future is concerned, we have to decide.
Lordship will upheld the pay fixation, but no recovery till the passing of the order. Otherwise, he'll have problem in his pension processing, my lord, before AG.
Yes. One is that by virtue of Rafiq Masi and all, and by virtue of the interim order, you have enjoyed the pay protection benefit till date. And that pay protection is because of that appointment initially as a driver, though you have participated in a selection process for the post of peon. And at that point of time, the post was not vacant. It was that original driver was under suspension, kept under suspension. Then when he has been reinstated, do you have the judgment of that man?
On, yes.
Copy of the judgment of that Boyso or something?
Anil Bushra.
Boyso
Do you have a
not
copy of the judgment?
No,
No,
it's not.
no
there.
antimony judgment is here.
Well, he was suspended perhaps.
He was suspended,
He
yes.
was suspended, I think.
They have to
So
dismiss.
that suspension does
Suspended.
not mean creation of vacancy.
Mm.
Suspension does not mean creation of vacancy. That
Yes.
Yes.
post was never vacant. Post of driver. So wrong was committed at that point of time. You should have been appointed as a peon. But because of the benevolence, what I could say,
Just to run the official work, that
Ah.
is why he was appointed.
benevolence, that order came to be passed, which has been rectified finally because of the judgment delivered in Anil Boyso's case. Right?
Yes.
As a result, you got reverted back to the post of peon, but with pay protection. And that continued, and that was sought to be removed by the impugn order. Then when you approached by this writ petition, that benefit continued. Along with that, the issue is refixation. That is also stayed. Right? That is also stayed. Now question is, one is refixation, then second part is whether pay protection, third part is recovery. If recovery not to be affected, up to what date? These are the issues?
Yes.
Up to
Okay. Let us proceed then.
Yes.
The present writ petition under Article 226 of the Constitution of India is preferred by the petitioner to assail an order dated order dated 30/06/2017 passed by the respondent number 4, that is the presiding officer, Labor Court, Guwahati, Assam, full stop. By the order dated 30/06/2017, in the order dated, the respondent number 4 as the appointing authority, as the appointing authority,
presiding officer labor court.
as the appointing authority, has observed that the appointment of the petitioner on 30/06/2006 be treated as an appointment in the post of peon in the office of the Labor Court, Assam, Guwahati, and his pay scale as per the revision of pay within bracket old be read as fixed from the date of appointment, that is, 30/10/2006. Full stop. In the order dated 30/06/2017, it has been further observed that the excess salary drawn by the petitioner since his date of appointment on 30/10/2006 be recovered. Full stop. Para. In order to understand the nature of challenge made. And its and its sustainability, comma, the necessary and relevant background events are required to be exposited. Fair. The petitioner came to be appointed temporarily on daily wage as driver, on daily wage basis as driver for a period from 19/7/2006 to 30/7/2006 in view of suspension of one Sri Anil Boisya, post of the at that time, comma, well, sorry, by an office order dated 19/7/2006 passed by the respondent number 4. Full stop. At that point of time, comma, Anil Boisya was serving in the substantive post of driver in the office of the respondent number 4. But, comma, Anil Boisya was suspended in contemplation of drawal of disciplinary proceedings against him. Full stop. An advertisement came to be published on 29/2006 by the office of the respondent number 4 and under the hand of the respondent number 5, inviting applications for filling up a vacancy in the post of peon in the office of the Labour Court, Assam, Guwahati. Full stop. The advertisement prescribed that the applicants should have the qualification of class 8 standard pass and the applicant should not be below 18 years and should not be above 37 years. Full stop. After processing the applications received in response to the advertisement, comma, the respondent number 5 issued an office order dated 10/10/2006, whereby the applicants whose applicants who were found eligible after processing of the applications, were asked to appear for interview before an interview board along with the original documents. Full stop. Please check the facts. If I go wrong, please correct me. It has emerged that for the seat post of peon, 16 number of candidates had applied, and out of the applications of those 16 number of candidates, 14 number of candidates appeared at the interview held on 27/10/2006. Full stop. The results of the interview process was declared on 27/10/2006 itself. Full stop. As per the selection list published, the petitioner secured highest marks in the selection process, and he was accorded first rank in the selection list. Full stop. Once Sri Noyanmani Sharma secured the second highest marks, and he was placed in second position in the selection list. Full stop. After the selection process for the post of peon was over, the appointing authority passed the following office order on 30/10/2006. Page 72. On receipt of the office order, above office order, dated 36/2006, the petitioner submitted his joining report on 30/10/2006 itself. Full stop. after the joining, comma, the petitioner was discharging the duties and responsibilities in terms of the above office order, and he was enjoying the scale of pay mentioned therein, right? Full stop. Para. In the meantime, comma, Anil Boisro who was holding the substantive post of driver comma preferred a repetition comma WBC number 4557 stroke 2010 before this court, and the said repetition came to be disposed of by judgment and order dated 1/4/2014. Full stop. In compliance of the judgment and order dated 1/4/2014, passed in the repetition WPC number 4557/2010, comma, an office order came to be issued under the hand of the respondent number 4 on 2/5/2014, whereby Sri Anil Boisro, Anil Boisro, had been reinstated to the post of driver in the establishment of the respondent number 4 in the establishment of a labor court, Assam, Guwahati, with immediate effect. Vice the petitioner transferred. Full stop. The office order dated 2/5/2014 further observed that Anil Boisro would be entitled to back salary and continuity of his service as per observations made in the judgment and order supra. The office order dated 2/5/2014 passed in respect of Anil Boisro was followed by another office order of even date in respect of the petitioner. Full stop. It will memo number DT bearing memo number page 20 আছে Anil Boisro আৰু page 21 petitioner in the office order dated 2/5/2014 passed in respect of the petitioner and under the hand of the respondent number 4, comma, it was observed that in the interest of public service, comma, the petitioner, comma, officiating driver in the establishment of the labor court, Guwahati, stood reverted, comma, transferred and posted to the post of peon within bracket with pay protection in place of Sri Noyanmani Sharma, who was working provisionally and temporarily in the post of peon till date. Post of. It is pertinent to mention herein because of his position, second place position in the selection list published after completion of the selection process initiated by the advertisement dated 20/09/2016. Sri Noyanmani Sharma was appointed by an office order bearing memo number LCG is 30.9 stroke 06 stroke 437-39 dated 30/10/2006 in the post of office peon in the establishment of labor code in the scale of pay. What else? Is 30 rupees so and so plus other allowances. With the further observation that the appointment was purely temporary and provisional. Full stop. By the office order dated 2/5/2014, passed in respect of the petitioner, the petitioner was directed to hand over the vehicle, key and other materials of the vehicle to the office and to join in his new assignment. Oh, sorry. Pertaining to Anil Bush. The petitioner, officiating driver, was directed to hand over the vehicle key and other materials of the vehicle at the office and to join in his new assignment given to him by the office order, by the other office order given it. By the office order dated 2/5/2014, passed in respect of a petition, the petition was directed to join in his new post immediately and to take over the charge of duty from Sri Noyanmani Sharma. And Sri Noyanmani Sharma, officiating peon, was directed to hand over the charge of duty to his reliever, that is the petitioner. Full stop. On receipt of the office order dated 2/5/2014, the petitioner joined in the post of peon by submitting a joining report on 2/5/2014 itself. Full stop. By another office order dated 8/7/2014, passed under the hand of the respondent number 4, the sanction was accorded for rupees 600 towards PN allowances of the petitioner, as a driver of the office on 1/5/2014. Right? These are facts.
Yes.
We'll resume at 2.
Fine.
Huh? Noyan Muni was also given pay protection.
Yes.
He was brought to High Court.
Both have received.
Huh?
Both have received.
There are other consequences in the judgment. This petitioner's status was also discussed in the
Noyan,
Noyan. Seriously discussed.
yes,
Facts are to be reconciled, Mr. Das, so that it should not violate the observations made in Noyan duty also.
yes. Some facts are not there, going to High Court and all those.
Yes, going to High Court, reverting back.
Back,
Noyan
those
duty Sharma, he was also given pay protection,
paper.
right? And on that page 25, writ petition,
Yes,
the page 25 writ petition, 17/5/2017, right? By this man, this petitioner was asked to show cause, right?
yes,
At the same time, the Noyan Jyoti on the same date was issued a show cause notice,
yes.
17/5. Then he was asked to show cause why he should not be discharged from the post. Noyan Jyoti. As because petitioner has been
Given,
and he was shown officiating
yes,
on 2/5/2024.
yes,
Then after petitioner he submitted reply. Then on 36, order was passed against Noyan Jyoti Sharma.
yes,
I think he was discharged.
yes.
And that has been set aside. Some questions were raised how this this petitioner should have been adjusted against that man who opted for voluntary retirement. Some zumbling of facts.
Actually, the impugn order which has been annexed here was also passed with respect to that Noyan Jyoti.
Oh, yes.
So it was a
He
common
was
order.
discharged.
Noyan Moni Sharma. I
He
guess.
was discharged. He was,
Commented.
Yes,
there you go. I think that is the context.
yes,
He was commented.
Let us put the facts, Mr. Das.
my lord.
We should not, it should not be against the other judgment also.
Yes,
I have to read because I was dictating in court. So
Yes,
let
sir.
us put the facts first.
Fine.
Then we'll put it on some other date
Yes,
so that
yes, yes.
there's no violation. Right, Mr. Sharma, because we'll not conclude today.
Yeah.
We'll put the facts so that nobody is prejudiced.
Yes,
If by passing any order again, Noyan Jyoti is prejudiced, then it will be difficult
yes, my lord.
to reconcile.
No, my submission, my lord, if the
Your
recovery-
submission,
recovery
let
cannot be made.
put the facts.
Mm.
Submissions will, you
Yeah.
preserve your energy for on the next date. Let us.
Petitioner should get the relief what he prays, my lord.
No, Mr. Sharma, please, what I have said, please, have you heard?
I'm hearing, but I find it difficult to catch because the
Said that because I have read Nayanjoti Sharma's judgment passed by a coordinate bench just now, right? So there are facts which are common
Yeah.
and have consequence in this petition also. So we'll put the facts first on paper. Then we'll decide how to reconcile and how so that it is in conformity with the other judgments. And nobody should be disturbed prejudicially. Please explain it to Mr. Sharma. It has further emerged from the materials that by an office order dated 27/7/2010, passed by the respondent number 4, the services of Sri Nayanjoti Sharma was deputed to the High Court and subsequently by another office order dated 2/5/2024, comma, of the passed by the respondent number 4, comma, Nayanjoti Sharma was appointed and transferred to the post of Yon with pay protection against a post that had fallen vacant upon the retirement of another
Bipin Bujar Bora.
in the post of peon,
Bipin Bujar Bora.
comma, VIJ, Bipin Bujar Borua. Bipin Bujar Borua, who was serving as peon in the establishment of the respondent of court, opted for voluntary retirement and his request application for voluntary retirement was accepted by an office order bearing memo number LCZ page 32 underline, dated 2/5/2014. Many things happened on 2/5/2014.
Yes, that's right.
Huh?
Yes.
And it was after acceptance of the voluntary retirement of Sri Bipin Bujarbura with the said office order dated 2/5/2014, comma, Nayanjoti Sharma was appointed and transferred to the post of peon, which post had fallen vacant due to the voluntary retirement of Sri Bipin Bujarbura with pay protection. Full stop. Para. Then there is one more, Sanatan Daka. He created the problem. both for petitioner and Noyan Buja Burwa,
Yes.
no, Noyan Jyoti Sharma. Para. Noticing that petitioner was appointed in the post of a driver by the office order dated 30/10/2006. After his participation in a selection process held for the purpose of filling up a vacancy in the post of peon in the establishment of the Raspanda Fort and his reversion and posting to the post of peon in the year 2014 wide the office order dated 2/5/2014 with pay protection comma the petitioner was served with a show-cause notice on 17/5/2017 by the under the hand of the respondent number 5 on the premise that such pay protection was not in conformity with the rules. Full stop. The petitioner was thereby asked to show cause as to why the excess payment received by him in view of pay protection should not be recovered. Full stop. In response to the so-called notice dated 17/5/2017, the petitioner submitted his reply to the so-called notice on 23/5/2017. Full stop. It is also pertinent to mention that on (17/5/2017), Noyanmoni Sharma was also served with a show-cause notice asking him to show cause as to why he should not be discharged from his post as by the order dated, office order dated. Two five 2014 pertaining to him. He was shown as an officiating peon. Full stop. Nayanmani Sharma also submitted his reply to the show cause notice on 22/5/2017. Full stop. The respondent number 4 had thereafter passed the order, impugn order dated 30/7/2017. Observing that holding that the appointment of the petitioner on 30/10/2006 was to be treated is to be treated as an appointment in the post of peon in the establishment of the Labor Court Assam, Guwahati, and his pay scale as per the revision of pay rules old is to be refixed from the date of such appointment, that is 30/10/2006, and the excess salary drawn by the petitioner since his date of appointment on 30/6/2006 be recovered. Full stop. On 30/6/2017, another order was passed in respect of Nayanjyoti Sharma, whereby what was done?
Page 33, my lord.
Thirty-three, which part?
My lord, first, second, third, fourth paragraph. Thus, Sri Noelmani Sharma has no legal right to continue his service as so and so.
When it was held at, he had no legal right to continue his service as peon in the office of the Labor Court, Assam, Guwahati, as his appointment, initial appointment, was illegal. Post of Noelmani Sharma, by the said order, was terminated with immediate effect, right?
Yes, Madam.
Post of. The order dated 36/2017, passed in respect to the petitioner, has been put to challenge by the instant writ petition. Full stop. The order dated 36/2017, pertaining to Sri Noelmani Sharma, was assailed by Sri Noelmani Sharma in another writ petition, WPC number 4083/2017. And the said writ petition, WPC number so and so, was decided by judgment and order dated 17/6/2022. Full stop. It is. Sorry, I have heard Mr. K. Sharma, learned counsel for the petitioner, and Mr. H. Kiras. Mr. Angusami, learned junior government advocate Assam for transplant number 1 and 2, and Mr. H. Kiras,
3 and
learned
4.
standing counsel. What did I put for transplant number?
3 and 4, Madam.
What about 5?
5, there are
Okay.
register.
5. 1, 2, 5, Aru, 3.
Register level 5.
Full stop. It is in the learned counsel for the parties have advanced their submissions in a backdrop of the above obtaining fact situation, which are narrated already carrying above. What is the consequence of Noelmani?
Normally he has joined after this, he was also in service by the stay order, my lord.
Directed to be reinstated.
On strength of stay order, he is continuing till the passing of this order. And ultimately it was.
He was, interim order was passed also in
Yes,
his
yes.
favor.
He was continuing.
Where is that? Interim order marks, anything there?
Page 58, my lord.
Ah.
The implication of setting aside of the order of termination
No.
would be there.
The interim order was passed.
That thing, A7, and WPC.
The termination 36 is set aside.
Of 17.
As he was otherwise entitled. No specific order that pay protection should be extended to Noelmani Sharma.
Normally, no, his stay was also granted up till further order. Accordingly, he is also in service. till today.
Then what is the consequence? No, okay, he has been reinstated.
Okay.
Termination has been set aside.
Terminal said that.
Now, it is order is that he paid all service benefits which he was otherwise entitled.
Okay. He was getting all this.
What benefit he has been granted, Mr. Das? What is the implication of this?
That instruction I'll have to take what benefit he was given after.
Enjoying,
Yes,
enjoying after
Yeah,
setting aside of the termination order.
yes.
he's
That is-
enjoying the pay scale that he
I
that
don't
he has
know.
given.
It has to be in black and white.
Yes,
Otherwise, the all service benefit which he was otherwise entitled. Otherwise entitled means under the law.
What he entitles because he is getting the same pay scale which says only that of passing of the order and it is
No,
continuing.
what he was enjoying? He was enjoying what? Pay protection.
no.
Of which scale?
No,
He was appointed as peon. Then he came on deputation.
no and money. Yes,
Then when he was reverted back,
he'll get the pay of peon
no, then he was given pay protection.
Yes, pay
of
protection
the
was given.
deputation force.
Benevolence
Pay protection was given because
by
by law,
Mr. Das
after his appointment in the post of Bipin
or
Kumar Gurua,
Mr. Goswami maybe. See see page 50. 53. Paragraph 4. Paragraph 4.
Yes,
Services of the petitioner is deputed in the High Court as a requestment, as per requestment. And further, by another order dated 2/5/2014, presiding of the Labour Court, the petitioner was appointed and transferred to the post of peon with pay protection.
pay protection is given because by law, in this post of Bipin Bujagurua, he is appointed newly. So in appointing newly, he was not given the initial.
Oh, pay
initial-
protection of
he
peon.
was-
No. Then he.
he was sent on High Court, but
Pay
peon.
protection means.
He'll get the pay of peon
Pay
because he
No,
was
no,
terminated.
Pay protection
The
means
termination, he was not given the initial scale. Original scale he is doing.
a pay protection
Yes.
because otherwise he is shown as a new
New
New.
appointee.
But originally, what he was
peon
doing, that was
was
given.
pay he was
But
given
his pay protection is from the date of
Original appointment.
appointment.
after setting aside of the.
But-
Yes,
This petitioner case is different.
this is different. This is different.
Because
Then
as
now
peon,
the cloud is over.
Yes,
he was doing the salary, one scale. So after appointment,
No, your case is, this petitioner case is different from Noyan.
no, same thing, my lord. Because when he was working as a LD assistant, because his pay is increasing by increment.
Right.
Increment.
That is
So,
project.
Yes, when he was reverted, he was posted in the peon of Bipin Bujagura. It is the new appointment. That is why he has to be given the initial pay. But instead of giving the initial,
Okay.
he was given the earlier scale by
Okay.
giving pay protection.
We need not have to discuss that then.
it's not required.
Then we can decide.
Yes, ma'am.
Mr. Sharma. Learned counsel appearing for the application has submitted that there was no fault on the part of the petition behind his appointment as a driver by the office order dated 30/10/2006. Full stop. It was by virtue of his appointment as a driver by the office order dated 30/10/2006, comma, the petitioner was granted the pay scale of a driver, comma, which was admittedly higher than the pay scale of a peon. Full stop. The petitioner was reverted back to the post of peon after the judgment and order passed in the writ petition WPC number 4557/2010, whereby Anil Vaishya was directed to be reinstated in the post of driver. Post of. Since the petitioner was had emerged as the first ranked candidate in the selection process, the process initiated by the advertisement dated 29/2006, and after his appointment as a driver on and from 30/10/2006, he was enjoying the pay scale of the post of driver, comma, albeit higher, comma, the petitioner was granted pay protection when he was reverted back to the post of peon by the office order dated 2/5/2014.
Look.
Post of.
May I just take leave, Mila? Another matter is come. I'm grateful.
The petitioner continued to enjoy the pay scale of a driver since the date of his appointment on 30/10/2006 till the passing of the impugn order dated 36/2007. Full stop. The impugn order, as the impugn order dated 36/2017, has also been stayed by an interim order dated 21/7/2017. The petitioner has been enjoying the higher pay scales than the pay scales, higher pay scale of pertaining to the post of driver. Though he is serving in the post of peon. on and from 2/4/2014. Full stop. Contending as above, comma, Mr. Sharma has submitted that, as further submitted that the impugn order as regards recovery of the excess amount since the date of the petitioner's appointment on 30/10/2006 is not sustainable, as the same would be extremely harsh. Full stop. He has further submitted that the benefit of pay protection, the petitioner is also entitled for the benefit of pay protection, of the benefit of pay protection. For in the future too, as he has been enjoying, as the petitioner has been granted such pay protection since 36/2000 for a substantial period of more than 17 years since 30/10/2006. Full stop. In support of his such submissions, comma, Mr. Sharma has referred to and relied upon the decisions of the Honorable Supreme Court of India in Shyam Babu Verma and others versus Union of India and others, comma, reported in 1994 to SCC 521 and State of Punjab and others versus Rafiq Masi within bracket Whitewasser and others, comma, reported in 2015 for SCC 334. He has also referred to the judgment and order rendered in the writ petition WBC number 4083/2017 within bracket Noyanmoni Sharma versus the State of Assam and 3 others, to contend that as the petitioner therein, that is Noyanmoni Sharma, has been enjoying the pay protection, benefit of pay protection, the petitioner should also be entitled for similar benefit of pay protection. Full stop. Mr. Das Learned Counsel for the Learned Counsel, Standing Counsel, ZH, has submitted that since the petitioner had participated in a selection process initiated and concluded for the purpose of filling up a vacancy in the post of peon, comma, he was, comma, by no means, comma, was entitled to enjoy the pay scale of driver on the strength of an order passed erroneously on
30/10/2006.
30/10/2006. Post hoc. It is contended by him that Anil Vaishnav was only placed under suspension in contemplation of trial of department proceeding at that point of time, that is on 30/10/2006. And suspension does not result in cessation of employment. Full stop. Does, comma, the petitioner could not have been appointed substantively in the post of peon or driver on 30/10/2006, as there was no vacancy in the post of driver in the establishment of the labor code, Assam Guwahati, on 30/10/2006. Full stop. It is further submitted by him that the petitioner had accepted his reversion to the post of peon on 2/5/2014. And since 2/5/2014, the petitioner has been discharging the duties and responsibilities attached to the post of peon only. Full stop. At best, comma, the petitioner would be entitled to enjoy the skill of a driver only till 2/5/2014. For a subsequent period, comma, the petitioner is not entitled for pay protection as the pay scale of every post is fixed as per the revision of pay rules and the concerned service rules. Full stop. In such view of the matter, comma, the principle discernible in Rafiq Moses Supra be applied in the case of the petitioner only for the period from his initial appointment on 30/10/2006 to his reversion to the post of peon on 2/5/2014, as it appears that he had perhaps discharged the duties and responsibilities attached to the post of a driver during that period only. Full stop. I have given due consideration to the submissions of the Landed Council for the parties and have also considered the materials brought on record by the parties through their pleadings. Full stop. I have also gone through the decisions cited at the bar. Full stop. Para. As there is no dispute to the fact that as on 30/10/2006, comma, the pay scale in relation to the post of driver was admittedly higher than the pay scale in relation to the post of a peon. In the establishment of the labor code Assam Guwahati, post of. At that point of time, comma, the pay scale for in the post of peon was 2,450 pra 3670. In Yatlikata. Whereas the pay scale in relation to the post of driver was rupees 2,650, ending with rupees 5,200. Full stop. The pay scale of both the posts have undergone revision from time to time, and the same situation that is the same situation as regards the pay scale exists as on date. What's the meaning thereby, comma, the pay scale pertaining to the post of driver in the establishment of the labor code of Assam Guwahati is higher than the pay scale pertaining to the post of peon in the same establishment. Post. Para. The petitioner from the it is not in dispute that the petitioner advertisement dated 29/2006 was published for the purpose of filling up a vacancy in the post of peon. In the entire selection process was initiated and concluded for the purpose of selecting a candidate for filling up the said vacancy. Most of the candidates were never in doubt that they were participating in the selection process for filling up a vacancy in the post of peon in the establishment of the labor code Assam Guwahati. Post of. But the response number 4, perhaps under an erroneous belief that there was vacancy in the post of the driver. in the establishment of labor code, Assam Guwahati, due to the suspension of Anil Boisro at that relevant point of time, had proceeded to appoint the petitioner in the post of driver by the office order dated 36/2006. Though the petitioner emerged as the first ranked candidate in the selection list published for the purpose of filling up the vacancy in the post of peon. Post of. The Noyanmani Sharma emerged as the second ranked candidate in the seat selection process. And the response number 4 by another office order of event date appointed Noyanmani Sharma in the post of peon in the establishment of the labor Assam. Full stop. Had full stop. Wherein the petitioner ought to have been appointed as the first ranked candidate in the selection list published after conclusion of the selection process. Full stop. The situation got disturbed. Sorry, sorry. The seat situation persisted till 1/4/2014. That is until the delivery of the judgment in order dated 1/4/2014. In the writ petition, WBC number 4557/2010, preferred by Anil Boisro, full stop, as a direction was made in the said judgment and order for reinstatement of Sri Anil Boisro in the substantive post of driver in the establishment of the labor code, Assam Guwahati. The response number 4, in order to alleviate. In order to restore alleviate the situation had passed the three office orders in relation to Anil Boisro, the petitioner, and Noyanmani Sharma. Full stop. On the said that is on 2/5/2014, another event had occurred as as an incumbent in the post of peon, Bipin Bujar Burua had opted for a voluntary retirement, and his application for voluntary retirement accepted on 2/5/2014, resulting into a vacancy in the post of peon in the establishment of the Labour Court, Assam. By the first office order is 31 of October. Anil Vaishnav, dated 2/5/2014. Anil Vaishnav was reinstated to the post of peon in the establishment of the Labour Court, Assam, with immediate effect, showing that the petition had been transferred. Full stop. By the second order bearing number so and so, the petitioner, showing him as an officiating driver, was reverted, transferred and posted to the post of peon with pay protection in place of Nanmani Sharma, stating that Nanmani Sharma was working provisionally and temporarily in the said post. Full stop. By the third office order, pertaining to Sri Nanmani Sharma, Nanmani Sharma, showing him as an officiating peon, was appointed and transferred to the post of peon within bracket pay protection, which was fallen vacant due to the voluntary retirement of Sri Bipin Bujar Burua. The petitioner, after the office order dated 2/5/2014, had immediately joined in the post of peon by submitting his joining report on 2/5/2014 itself. Full stop. Thus, it is not in doubt that since 2/5/2014, the petitioner has been discharging the duties and responsibilities attached to the post of peon in the establishment of the Labour Court, Assam. And he, since 2/5/2014, the petitioner had never discharged the duties and responsibilities attached to the post of peon, so driver, in the establishment of the Labour Court, Assam. Full stop. By the impugn order, dated 36/2017, the impugn order dated 30/6/2017 is likely. No, the petitioner is likely to be visited with three conscience by the impugn order dated 30/10/2006. Full stop. Firstly, comma, his appointment, a petitioner's appointment is to be treated as an appointment in the post of peon in the establishment of the labor code, Assam, on and from the date of his initial appointment on 30/10/2006, semicolon. Secondly, comma, the scale of pay of the petitioner is to be refixed as per the revision of pay rules from the date of his such initial appointment on 30/10/2006, semicolon. And thirdly, comma, the benefit of excess pay enjoyed by the petitioner from on and from enjoyed by the petitioner in the scale of pay in relation to the post of driver is to be recovered from 30/10/2006. Post. Well, though the contention of the learned counsel for the petitioner that the petitioner, since the petitioner is enjoying the higher pay scale since his initial appointment till date, he should be granted, he should be continued with such benefit, and the said benefit should not be withdrawn. Appears attractive, comma, the same is not found sustainable in law. Full stop. The pay scale in relation to a post is fixed as per the extent concern and extent service rules, and also by the revision of pay rules. Post of the revision of pay rules are framed under the proviso to Article 309 of the Constitution of India. Full stop. As such, comma, such rules are constitutional rules. Has a constitutional character, are of constitutional character. Full stop. The petitioners reverse. No. The an employee holding a particular substantive post in the concerned service is only entitled to the scale of pay as fixed by the concerned service rules and the revision of pay rules. And any authority cannot cannot grant any benefit of any higher scale contrary to such scale of pay which is attached, which is in relation to that particular post of any such benefit of higher scale given by any authority, be it the appointing authority, would be contrary to law. Full stop. There are now since his date of appointment on 30/10/2006, the period of service or the petition can be bifurcated. Trifurcated. In that, it can be considered in 3 phases. Full stop. With the first phase being that from the date of his appointment on 30/10/2006 by the office order of event date till his reversion to the post of peon by the office order dated 2/5/2014. Post of the second phase was on and from 2/5/2014 to the date of the impugn order dated 30/6/2017, and the third phase is from the date from on and from 30/6/2017 till date in view of the interim order dated 21/7/2017. First off, insofar as the first phase is concerned, that is from 30/10/2006 to 2/5/2014, the petitioner had discharged the duties and responsibilities of the post of driver in the establishment of the labor code, Assam, by virtue of the office order dated 30/6/2010, albeit passed unauthorizedly by the
2006 Lord.
6, albeit passed issued unauthorizedly by the appointing authority, and on the strength of possession of a valid driving license. You get a driving license? Or otherwise, I curtail that also. You have a driving license.
Yes.
Full stop. On and from
Mhm.
during the second phase, that is on and from 2/5/2014 to till
Okay, he has driving license, so he was a driver originally.
30/6/2017. Comma, the petitioner had enjoyed the higher pay scale of the driver, in view of the order of pay protection recorded in the office order dated 2/5/2014 by the respondent number 4. Full stop. There is no discernible act. There is no act discernible and attributable to the petitioner which can be said uh, which can be said to be behind the office order dated 2/5/2014. It was solely the it was the respondent of board who, as the appointing authority, had extended the benefit of pay protection, thereby, allowing the petitioner to enjoy the higher pay scale of the driver during the period from 2/5/2014 to 30/6/2017. For the third phase, that is for the period from 36/2000, no, it was only in the year 2017, the appointing authority had realized that the benefit of pay protection was erroneously extended to the petitioner and with such realization, the so-called notice dated 17/5/2017 was served, and thereafter, the impugn order dated 36/2017 was passed. Full stop. During the third phase, the petitioner has enjoyed the benefit of higher pay scale of the driver due to the stay of the impugn order dated 36/2017 by the interim order dated 21/7/2017. Full stop. Where in the Honorable Supreme Court of India in Rofiq Masih Supra has, with regard to recovery of excess pay, comma, has observed as under paragraph 18.
Paragraph 18,
18.
18, 1,
Order लिखी हुआ Mr. Das standing counsel. GC has referred to a decision of the Honorable Supreme Court of India in Union of India and others versus Panwarlal Mundan, reported in 2013.
12 SCC
12 SCC 433 to contend that the matter of refixation of pay scale, if the pay scale of an employee was erroneously fixed earlier, would fall within the domain of the employer. Admittedly, the petitioner was appointed in a grade 4 post, be it a driver or a peon. Both are grade 4.
No lordship. Driver grade 3 lordship.
Huh?
Driver.
yes.
Grade 4 or grade 3?
I will have to say.
Huh?
Get for my lord.
Driver.
Grade 4.
Yes. Over
Grade
my
4.
lord, presiding officer, level 2.
It is there. No, it would be it, but Hmm. The fixation of the erroneous fixation of a higher pay scale by the order dated 30/10/2006, either by the order dated 30/10/2006 or by the order dated 2/5/2014, was not on account of any misrepresentation or fraud on the part of the petitioner. Full stop. The fixation of pay at a higher skill by the erroneous appointment in the post of driver by the office order dated 30/10/2006. And by the and extension of the benefit of pay protection by the office order dated 2/5/2014 was solely attributable to the employer appointing authority stroke who by applying a wrong principle for calculating pay, allowances, etc., or on the basis of a particular on the basis of a principle, which was subsequently found to be erroneous. Full stop. In such view of the matter, the principle laid down in Raptic Masjid Fitra, insofar as the recovery of excess pay is concerned, is found applicable to the case in hand. Full stop. In such view of the matter, the order, direction made in the impugn order dated 30/6/2017, insofar as the recovery of excess salary drawn by the petitioner since his initial date of appointment on 30/10/2006 is liable to be set aside and passed. It is accordingly held. Meaning thereby, there shall not be any recovery of excess pay from the petition for the period from 30/10/2006 till date. Full stop. Whereafter. In Shyambabu Burma, it has the petitioners were found entitled only to the pay scale of rupees 330-480 in terms of the recommendation of the Third Pay Commission WEF 1973. And only after the recovery of only after the period of 10 years, only after a period of 10 years, para 11%, they became entitled to the pay scale of rupees 330-560. But as they had received the pay scale of rupees 330-560 since 1973 due to no fault on their part, and that scale was being reduced in the year 1984. WEF 1973, it was held to be just and proper not to recover any excess amount which had already been paid to them. So it was directed that no steps should be taken to recover or to adjust any excess amount paid to the petitioners due to fault of the respondents. The petitioners being in no way responsible for the same. Full stop. The decision does not lay down anything. No, full stop. The decision, not like, it is, the decision is only with regard to the decision in only in Syambabu Verma Supra is only with regard to non-recovery of excess pay, like Rupik Masi Supra. Full stop. It has been held in the decision in Anwarlal Mundan is with regard to error pay fixation, error in pay fixation, and the power of the employer to rectify. Error in fixation of pay. Full stop. Two questions fail for consideration in Vanwarlal Mundan, semicolon, firstly, whether two question, two in a case of such nature, two questions are required. The core question required to be examined is whether the pay of an employee was erroneously fixed. Full stop. If it is found that fixation pay it has been observed in so and so that if fixation of pay is found to be erroneous, then the authorities, then the authorities would be well within their domain to rectify the same. Full stop. As the petitioner is only entitled, only found to be post of no, no, okay. It is relevant to mention that the petition, on being reverted back to the post of peon by the order dated 2/5/2014, had never challenged the said order. Thus, the said order had attained finality insofar as the petitioner is concerned. In that view of the matter, the petitioner is only entitled for the pay scale attached to the post of peon of peon. The petitioner was selected only for the vacancy in the post of peon in the selection process undertaken, and as such, and at the date of appointment of the petition on 30/10/2006, it was only a post of peon which was vacant. Full stop. Answer A2. Attained final. The fixation of pay scale of the petitioner is therefore required to be refixed from the date of his original appointment on 30/10/2006, and also in such view of the matter, that part of the impugn order dated 36/2017, whereby it has been held that the appointment of the petition is to be treated in the post of peon in the establishment of the labor quota sum is to be treated in the post of peon, in the establishment is to be treated. Sorry, the appointment of the petition on 30/10/2006 is to be treated as an appointment in the post of peon in the establishment of labor quota sum, and accordingly, his pay scale is to be refixed as per the revision of pay rules from the said date of appointment, that is, 36/2006, does not call for any interference. Full stop. In view of the discussion made above and for the reasons assigned therein, the writ petition stands partly allowed to the extent indicated above. Full stop.
This case is relating to the refixation. My case is not for refixation. He was given the scale of driver and 2006, thereafter 2014 with the pay protection. That is not the case of refixation, my lord. Refixation what? If there is wrongly fixed in the annual increment and in that way there is a mistake in refixing then this will be applicable, my lord.
And such
It is not the case.
it is further made clear
My case
that
is not the
such
refixation, my lord.
refixation, if due to such refixation, the sorry, the benefit of refixation will be only prospective. Though, sorry, it will be refixed, but the benefit as regards the pay and allowances resulting from the prefixation will be of prospective character from the date of this order,
And
meaning there were no recovery.
in case of pay fixation, Nayan Mani Sharma, he has got the entire benefit.
Okay, you want the explanation? Okay, I am getting.
Same benefit.
Though Mr. Sharma has strenuously contended that the Nayan Mani Sharma, the case of Nayan Mani Sharma as regards pay protection is similarly situated to the petitioner, such contention is only to be rejected. Full stop. The case of Nayan Mani Sharma is completely different from the case of the petitioner as regards the matter of pay protection is concerned. Full stop. Rightly or wrongly, the Nayan Mani Sharma, who was the second ranked candidate in the selection list published for the lone vacancy of peon, lone vacancy in the post of peon, he came to be appointed as a peon by an office order dated 30/10/2006. Full stop. Since on and from 30/10/2006, Nayan Mani Sharma continued to discharge the duties and responsibilities attached to the post of peon till 2/5/2014. And thereafter also by the office order dated 2/5/2014, when he was appointed, appeared to be freshly appointed in the post of peon due to the vacancy which arose pursuant to the voluntary retirement of Sri Bipin Bujarboro. Full stop. The office order dated 2/5/2014 was with pay protection. Though by the said order, Noyanmani Sharma was shown to be freshly appointed. Full stop. The reasoning behind pay protection perhaps was for the reason, perhaps for the reason that, the reason behind such pay protection was that since 30/10/2006, he was discharging the duties and responsibilities of the post of peon. And full stop. It was in that background, when by the judgment and order dated 17/6/2022, passed in the writ petition 4083/2017, the termination order of Noyanmani Sharma was set aside and quashed. It was observed that he should be paid all service benefits which he was otherwise entitled. Full stop. Such is not the case of the petitioner here. Full stop. The petitioner wants that while discharging the duties and responsibilities of the attached to the post of peon, he should be given the benefit under the guise of pay protection, the pay scale of the higher pay scale higher pay scale entitled higher skill for the post of a driver. When under the revision of pay rules, there is under the revision pay rules, the pay scales attached to the post of peon and the driver are different. In such view of the matter, the contention advanced by Mr. Sharma is clearly unsustainable in law. Taken care of. Now, it is for you to. I thought that I'll leave it aside.
Deeply obliged.
May I please your lordship?
Yes, Mr. Burwa.
That is a third round of litigation, my lord.
Third round.
Third round. That is first round was started from 2003,
Hmm?
2003 and 2016. Now it is fact is this. my
I
lord,
don't
I'll
know
give-
any of the rounds. I don't know any of the rounds.
You will be knowing, my lord. Your lordship will be aware. Decide that's why I'm putting very easy.
You might be the player in all the 3 rounds.
No, that was the mistake. I was not player of that. Now only I become player. But here, what happened, my lord? Today, your lordship, one question will
What is
come.
the
that-
case about? Please tell
Yes,
me.
yes, I'll tell you. Sir. There is stadium, my lord. Sorusaja Stadium, when it was constructed, 5 bighas of my land was acquired by the government. Due procedure following. But I think what manner it was been, I do not know that particular moment. Compensation not paid. Rather, this honorable court also passed an order. The first order, the immediate dispose of in the meantime, endeavor will be made to allot the alternative land. Alternative land, Miller.
Your 5 bighas, around 5 bighas.
5 bighas alternative land. Then
It was
thereafter,
acquired.
acquired. That is no doubt in that.
When?
2003.
Meaning by Land Acquisition Act 1894.
That is it.
Okay.
Now I'm coming on, Vision. Then acquired land. Thereafter, he has approached initially filed one case before this honorable court.
Writ petition.
Writ petition. Our honorable passed then very simple order that a division will be disposed of, and in the meantime, allotment of alternative land may be considered. On view of that, it keep on going. It is a discussion is going on. Ultimately, 2014, again this procedure, there is never whispered that this land will be not allotted or nothing. Only discussion or later keep on writing letters only. Thereafter, this another petition has come 2014. During pendency of that 16, during pendency of the petition, one letter has come that this petitioner will be allotted some bighas of land. It is 20 bighas of land. This one it can be allotted. This on the basis of that letter, our honorable court disposed of that matter. That is a very good order. What happened? Then that within time it is not been done. Anyhow, Lordship see orders. Then I'll not say name. This one due to some problem. There's allegation and other things that has come up. That is why. In the meantime, now processes again it is going on that it will be allotted. In the meantime, in terms of this, our judgment in past in 2016 case, 4-member committee was constituted. Government. The government also stated that okay, fine, you can be earlier it was 32 bighas of land. But committee has decided no. As per value of the land, you will be entitled for 22 bighas. That is in that side, other side of Guwahati. That was then again process is going on. Discussion is going on. In the meantime, our Advocate General also given order under provision of this as your lordship or legal opinion also going to be given. But all of a sudden, in 2002, letter has come. No, this land cannot be. No, land is not there now. That question has come.
Then money.
No, then I'll come now. Another we did only 1 point is there, no money will come. Then thereafter suddenly it has come. No, they're not telling. The money they have not said. That letter is said, no, this all land is been allotted to this ANC and all the things and the other department will be given. Now no land is there. Whereas previous letter, it has been government to return that land bank will be allotted, but fine morning, ADC has written no, it cannot be allotted. Then we have approached this honorable court. During approach this one, now my learned friend has filed affidavit. Now straight away 4 lines, only affidavit is very short. Only 2 paragraphs. I have no need to return. That no, there is no back end land at all now. Now your lordship, the money will come. Now that is the decision. Now in this regard, my lord, if money comes after 20 years of litigation, that is, I'm starting with litigation, then what manner it will be paid, this to be also seen. I have to take also instruction. Now, today only
Undoubtedly 2013.
That will come, definitely it will come. But no, before that, my humble submission today, because it cannot be, it is a very big petition, my lord. All documents will be seen before disposal. In the meantime, record also has been called for. We have seen also record for. It is a fact that land is acquired. It is fact. No payment is made. That is fact. No land is allotted. That is fact.
Then ultimately it boils down to fact.
Fact. Now
Land
only.
of measuring 5 bighas.
Yes. Now, my lord.
Had been acquired.
Now only.
Against that acquisition, no money paid.
No money paid. And according to them, earlier they were saying, cannot be, we have no land.
But-
Now straightway affidavit say, no land is
So,
available. Now my
Statutorily and legally, you are entitled for
yes,
money.
yes. Now
No doubt about
if
it.
there is
This stand, that stand,
if there is no land, I have to get money.
money.
But only my humble prayer before Lord today, only because straightway I also I also cannot go, state I can.
But
cannot travel.
this is a new petition, 2023.
It is 23,
Ah.
but coming from 2003 onwards, it is Millard.
Ah.
This is a linkage. Linkage is
Yes.
coming up. My
May not
lord,
be
here
possible
only,
today, Mr. Borua.
no, here only today, if your lordship put one observation only, it will be helping for both of us. If it is of petition. Only I may be, your lordship due permission only, may I submit, Millard?
Yes.
Yes, my submission is this one. If by affidavit they are saying no land is available, in that case, what manner it will be compensated to me? And how much money will be compensated to me?
No,
Let them take instruction, Millard.
Mr. Borua, that process requires quantification and
This
that
way-
has to be, oh, no, that they are not coming up.
Who is?
Perhaps the state respondents are not coming up with a specific solution.
No, that is why before lordship, before
Right,
lordship has to see
right.
now.
Now, this has to be that quantification.
Yes,
It is, if there is an offer of money, that is one thing.
yes,
But otherwise, this quantification is to be of the compensation is to be as per the formula prescribed in 2013 Act. And that requires a process. Valuation at that point of time,
Yes.
present valuation of
Yes,
that
well-
particular lands, that requires a huge
yes, yes,
process.
definitely because it is not.
That-
paid.
That a time limit, if the decision comes in that way, suppose,
These way.
hypothetically,
Yes,
then the direction would be that within a
Yes.
fixed time limit.
that is right.
Right.
Today only because there is no time also, possibly
there is
time
no
also.
time to hear it.
Only my, today because they have said my submission, I'm feeling only that way, because affidavit clearly says no vacant land. Let them put.
Feelings are exchanged or anything is.
Yeah,
required, Mr.
it
Talvira.
is a completed.
It may not be under 13 Act because, my lord, while acquisition process was on, my lord, they objected for their giving their land, my lord. Then the issue.
Any stay,
No stay,
then
no stay. So the acquisition was over. The money was, that value was assessed. And only they did not receive the money because on protest probably they did not. I'll have to check the record. And then money was probably lying there. So whether it will be under 13 Act or that money with interest for this.
Yes.
okay,
My
then
lord, let them, that is your lordship observed this way, this much only.
how, without knowing, I cannot.
No, my lord, let them, whatever saying. Okay, let them, if
No, they have filed affidavit or not?
affidavit,
One
file
simple
affidavit.
affidavit
Who has
that
filed affidavit?
DC,
Deputy comes.
deputy commissioner, right person has filed.
Right person.
Yes, DC is
Okay.
that person.
He has already filed then.
I have filed reply also to that effect.
Okay.
Now, what manner it will be paid
No,
and how much will be,
then,
let them decide first.
No,
Then-
whether all these facts you have said are there in your affidavit? I think.
No, not at all.
Their reply, they have said, what are the development?
But I have also seen record, my lord. Because all along it is,
Okay, tell me from your record, what is the quantification you have made
Quantification, the earlier,
earlier? At least a privacy view, to have a privacy view.
yes.
Really, you were serious at that point of time.
interest.
Oh, 1894 record.
Local market.
That's the main action. Payment request.
Payment nine
Address
law,
of payment yes.
9 law.
2013 account দিব। Award under section 11. Is there any award?
Lordship, I'll have to go through the records, whether I have. followed the
Because
record.
such contention will be acceptable
My-
when there is an award under section 11.
Because award has to be there because these people, all these people have taken the
No,
money.
all these people does not mean that petition.
petitioner did.
No, I have not.
Because there used to be separate award for each of the
Yes.
land acquired. There may be parcels, there may be a composite award, there may be different 100 awards.
I'll check the record.
Because every category of land may be different.
When my,
Petitioner's land may be near the highway, somebody else's
when my lord,
500 meter from the highway. Valuations are different. Award will be different.
when my lord, if we go by our judgment, latest judgment, everything has been clear. Now, don't have, your lordship, time is not there, and I have
Oh.
shown you everything. Now, this question is not even at all been raised. First and foremost, they have, no question is arising about allotment of land or anything. And nowhere it is whispered that award has been refused by me.
Because if there is no award under 11, then under 24 of the 2013 Act, everything goes.
If award is not there.
That is what. And the error is
For me, so
published.
far as I remember, the award was there and the money was paid to the other people.
Money was paid to?
Other people. He is not the only person.
Yes, I'm the only person because that is only because here I got protection from the honorable our court also. And then if at all they want to give last 20 years, they would have not kept me because they would have told me that okay, do not get the land, you take money. Nowhere. All if correspondence, your lordship sees all correspondence are for allotment, for even last Advocate General has given opinion that he can be given the properties or this land. This is the last age. Even 4 members committee has asked, 4-member committee directed to give the land. Thereafter, Accountant General view is there. Thereafter, now if at all my learned friend is saying that this cannot be, it is a really.
Mr. Borua, we cannot find out land for you. So that is.
We may.
What is the
My lord, one thing.
only solution before the court that we are.
No, one thing, my lord, it is there. Lordship, if you go, if time permits, if the lordship.
Find out that, produce the award, then everything will be in a different way. Otherwise, if there is no award, everything lapses so far as the petitioner is concerned.
Then it will be altogether.
Altogether different.
Lordship, I'll have to go through it.
Please find out.
Lordship.
Because award is to be in a particular form.
Yes.
Merely writing a amount will not do. Heard Mr. C. Borua,
For the
Learned Counsel for the petitioner, and P.R. Mohanto, Standing Counsel, Revenue for respond number 1 and 2, Revenue and Disaster Management, 1, 2, and 3. 4. Mr. Taludar, you are appearing for Deputy Commissioner. And Mr. Vijay Taludar, Senior Counsel, assisted by Mr. C.K. Mehdi, Learned Panel Lawyer, for a respond number 5 to 8.
5, 6, 7, 8.
5 to 8.
5 to 8.
Full stop. Mr. Taludar has sought for some time to apprise as to whether any order, any award in terms of the Land Acquisition Act 1894, within bracket since repealed, was passed in respect of the parcels of land belonging to the petitioner. Full stop. As sought for, release the case. Mr. Borua, Learned Counsel for the petitioner, has submitted that the present one is the 3rd round of litigation. Full stop. As sought for by Mr. Taludar, release the case on
You also will fix a date, my lord.
6 June 0606.
but that's because that should get finality. Whatever.
Oh, no. How can I know?
No, your lordship have to know now. Because if we would
I'll
have,
be here.
my lord, your
I may not be here.
May not be there, be Chambon, lordship will be there.
Definitely other, it is same one and the same thing.
No, no, your lordship will be there.
Lost the
Then
final.
accordingly, we'll put them. Lordship.
I don't know.
No, no, I don't.
I don't know about my roster. And why should I? I've not heard it.
No, no, that is why we want your lordship to get that much hard. Oblige, you
Mr. Ahmed thought it that it will be in the top of the list. I'll give a due consideration. But
May I pray that tomorrow at 2 because my age and health.
I
that
know,
is too, sir.
Monday or Tuesday, I thought that because on the belief that
Yes.
it will be on the,
Yes.
everything is
Yes,
not
I understand that.
within my estimation, right?
Lots.
And it is very little time to
Lots.
understand. I thought that it will be
Lots.
at the higher side and we'll try to give a consideration.
Lots.
Because these are all technical
Mm.
thing which are medical terminology,
Lots.
some legal bar,
Lots.
legal bar was there.
Yes.
I thought that, anyway, then Tuesday,
Lots.
choose one. Mm, Mr. A. Ahmed, Learned Counsel for the petitioner, and who are they there? MS A. Gayon, Learned Central Government Council for the respondent number
Number one.
1.
Yes.
Petitioners, huh? A. Gayon, Central Government Council 1, 2. 1, 2.
But yes, one and
Some amended cost title.
Yes, Lordship.
Uh,
That respondent number 3 was.
and MS
P. Rabha.
P. Rao,
P. Rabha.
Rabha, you are, okay, okay,
Yeah.
A. Gayon. Who is there, most important?
That is
Chief
my
Secretary?
health, my Nayak.
Nobody is there,
Bobo.
are present. The Learned Standing Council. Health and Family Welfare Department, Assam, is found absent today on call. Due to paucity of time, the case could not be taken up today. In view of the urgency expressed by the Learned Counsel for the petitioner, let the case be listed on next Tuesday.
21/5.
Pilot, 21.
Yes,
Yes,
any,
madam.
any difficulties?
No, no. 22, I have it. 21.
Oblige.
This is also difficult. I thought these are
Lordship, we have not received written instruction, Lordship.
no instruction.
Lordship,
Because
out of
to safeguard your interest, I
Yes, my lord, that is.
thought it fit to obtain.
Yes, my lord, my lord.
Otherwise,
My lord, I have only humble prayer before your lordship. Already, my lord has already at a length already
no,
heard the matter.
Mr. Counsel, I have heard at the motion stage. I cannot keep it part heard at the motion stage.
Yes, my lord.
And I'll not be, might be not available. So I cannot.
That is the problem, my lord.
Yes, when can you,
Lordship, on Friday, he is out of station, Lordship.
despite your death Friday, Mr. Kyle?
No, Lordship, officer is out of station.
Okay. Mr. S. Sharma,
Yes, my
for
lord.
the petition
Next Friday, Friday.
and MS
M. Decca.
M. Deka, Learned Counsel representing Mr. S. C. Kyle, Learned Standing Counsel DST for respondent number 224. Full stop. It is submitted by MS Deka. That the instruction, written instructions have not yet been written instructions sought to be produced in respect of an action of cancellation of registration.
My lord.
written instruction as regards consequences going out of an act of cancellation registry
My lord.
of GST register.
Yes, my lord.
Have not yet been received. MS Dhaka has thus sought posting of the case on next file.
On next file and also on 24th.
Huh?
On 24th, Lordship.
As per your lordship.
This
convenience,
Friday,
lordship.
Lordship.
24th. Right, 24th. Doctor. You want this your MP skill corporation?
Yeah.
Some PD one all. MP. He'll be given the
Yes.
citation, but good one. Your Tamil Nadu.
Obliged, my lord. And I learned,
Your Tamil Nadu.
yes, my lord, I learned very much from your lordship.
Good one,
particularly-
good one. MP one, good one.
Yes, my lord. Particularly who limitation period of special
Yes,
legislation. my lord.
special legislation.
Yes, my lord.
But still that is distinguishable.
It's my lord, my lord.
Anyway.
I learned from your lordship, my lord. Deeply obliged. my lord.
Yeah, like,
Colonel, is the case? Yes, Mr. Mojumdar, why you are waiting for? Can't help it now.
There is no urgency on our part as such. There's an interim order, lordship would only extend that.
Nothing will be recorded.
It
Left,
was till the next,
left over or what?
till the next date fixed, my lord, actually, it is the Sishugram, my lord, whose land the government was trying to revert back. The only interim protection we have.
No, no,
Nothing till now, my lord.
Mohanto,
my lord. After
You
long
want-
time, listed after long
you
time,
want
my lord.
this repetition to be decided on the doctrine of non-traverse. Have you understood the implication of doctrine of non-traverse?
My lord.
What is that? Nasir or Nasir Banu or what?
And Nasim Banu,
Nasim Banu. Nasim Banu.
if not controverted, will be admitted. Actually, it is the Sishugram's
Oh.
land, my lord, which they were. trying-
Okay, government wants 185 acres.
They wanted to take back the land which was already.
By the doctrine of non-traverse, they want to give it to you.
Yes, they want us to retain because they wanted it for the Ames College.
So you are
Ames Hospital.
donating 185 acres.
My lord. After a long time, it's listed.
What
by
is the
my
observation? Huh?
And it's some time, my
Then
lord.
this is last opportunity.
My lord. My lord. It's listed after a long time.
Heard, mister, that is not an excuse.
My lord.
Shall I record it?
Communications are made, my lord.
I record it.
No, not at all, my lord. The communications are made, my lord, but
So non-listing, no affidavit. Don't make such submission before the court. You were given 1 week. By default of non-listing, you have been allowed 3.5 years. Last what? At least a week.
1,500 weeks, then 52 weeks a year.
3.5 years. You are allowed time to file affidavit. By default. Heard Mr. R. Mojumdar and Council of Petitioners and MS PR Mohanto and Standing Council Revenue Department are present. Full stop.
even for 3 and 4.
This court on the previous date of listing, that is, on 18/11/2020, had observed as under second paragraph. It appears that non-traverse liquidable. Against Revenue Department, that observation. Let the fences eat the grass. MS Mohanto, Learned Standing Council, Revenue Department, has sought for 2 weeks' time
My lord, 4 weeks,
As a-
otherwise,
You have been granted.
they're protected, my lord.
No, it is your negligence,
My lord,
which is palpable.
my lord, 4 weeks, otherwise,
3 weeks time. As a last opportunity. To file. An affidavit in opposition. To extricate the department from the doctrine of non-traverse. First of, the pair made as regards last opportunity is accepted. At least the case on so and so. The interim order passed shall continue till then.
oblige.
Bless me. I'll give us. Nothing. No so here. And Gokul. Nobody is there. Yes, MS, Mr. Setia, who was there? M. Setia. He said,
Affidavit,
grant time,
we have filed our affidavit, Lord,
when?
on 16/11/23.
You
But,
did?
then
Okay,
affidavit is not in record,
Okay.
Lordship.
there is no representation on behalf of the petitioner today on call. Post of MS S. Borua, Junior Government, Bukit Assam, for the respondent number 2, 4, 13, 14, 15. Has submitted that an affidavit in opposition on behalf of the said respondent
Yes, Lordship.
has already been filed in
District Commissioner
January,
provided
February,
16/11/23,
in November
November.
2023
District Commissioner
Uh,
provided.
on 16/11/2023. As the said affidavit in opposition is not tagged with the case records, comma, the office to verify as regards the filing of such affidavit in opposition and thereafter, comma, to tag the same with the case records. Please the case after 2 weeks. You too. Oh, Mr. Roy, not possible today. Bad, tax.
Regarding refund.
This is, my lord,
Refund, madam.
I paid in source and TDS also been deducted, but which is not, there's a double taxation, my lord.
Not possible, Mr. J. Roy, Senior Counsel for the Petitioner, and Mr. B. Goy, learned
Taxation.
Standing Counsel Taxation, Finance and Taxation Department for the respondent.
13.
Are present.
13.
Yes, after 1 week. Yes.
On 21st, my lord.
21st.
One thing I believe not proper on my part because I will not be sitting. So on a hearing date,
30, my lord.
no, that is the same situation.
When, my lord, has-
That is the same situation.
In
I would fix when I know for sure that
after 2 weeks, my lord, in that.
this is otherwise certain that I am not sitting on those dates.
Lordship, as your lordship wishes.
After 2 weeks. After 2 weeks. You are enjoying or you are seeking refund?
Refund,
madam.
refund.
After
No
2 weeks then.
But-
Not an individual,
Yes, yes.
Not an individual.
not in a hurry.
I'm not in a hurry, but it's long pending, my lord.
As sought for by the learned counsel for the.
But date may be
It's
given.
after 2 weeks.
A date may be given.
This is the difficulty, Mr.
because I always move, my lord, that's the problem.
No, there is a difficulty fixing the case on a date where I do not know that I'll be sitting. It will be. This is anyway, it is on hearing list. It will come. 2018,
18.
it will come.
No,
After
only
2
thing, my
weeks, it will
lord,
come.
if,
After 2 weeks. Or shall I make it 1 week? 18, it will be coming.
then it's okay, my lord. No, I'm not saying that, my lord, because I have outstation matters, my lord, because
After 2 weeks?
2 weeks, okay, my lord, but